Welcome everybody to today's Legal Services Trust Fund Commission Rules Committee meeting. Can I have the staff do the housekeeping, please?
Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Rules Committee meeting. Thank you for joining us. We will begin shortly. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. To use the raised hand feature by phone, dial *9 on your phone's dial pad and the same to lower your hand. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. New going forward, all LSTFC and committee meetings will be recorded and posted to the State Bar website. A friendly reminder that this is a video conference and to please be aware of your surroundings behind you. Tip for those using Zoom on a computer, when on mute, holding down the spacebar will temporarily unmute. If you use your phone to dial into this meeting, please be sure your computer's microphone is on mute to avoid audio feedback issues. While joining audio via computer is highly recommended, if an individual loses audio, they can call in separately using the Zoom conference number. Thank you.
Amin, would you like me to take roll while we wait?
Yes, that'd be great. Thanks, Dawn.
Al-Saraf,
Present.
Whitemaster, Bennett,
Present.
I'm just trying to promote Catherine now. She should appear
Okay.
soon.
Okay. Great. Catherine, just in time for roll call, so Blakemore.
I'm here. Thank you. Sorry for the delay.
No, glad you made it in. Bocelli,
Present.
Connolly, and Erica did say she's running late, but she'll be here. Meeker,
Here.
we have quorum. Let me do the advisor, Judge Seligman. Is Judge Seligman here? And I'll do our liaisons. Melanie
Check,
Snyder.
Department 23.
Is that,
I'm here.
I'm not sure. Well, when we do public, yeah. Selena
I'm here.
and State Bar staff. I see Shannon, Chris. Is Brady on?
He is.
He is? Okay. Oh, I don't see him.
Oh,
I see him.
Oh, great. Okay. Hi, Brady. Okay, great. So I'll turn it over to you, Amin, to do public comments.
Okay, let's welcome everyone. Thank you for joining. Do we have anyone who would like to make a public comment, a general public comment?
There are two people. I'm not sure who they are. There's a person with a 323 area code, and then there's someone identified as a Department 23.
Could you unmute them, Kim, in case somebody wants to do public comment?
the phone number is me. I need an audio backup because my internet is
Oh, okay.
not good.
Okay.
Thank you, Will.
Great.
No problem.
Can you hear me?
Oh, Judge Seligman. Okay, we thought
Yeah,
that.
I'm having trouble. My Zoom screen doesn't give me a Zoom button or, I mean, a sound or a video button. So I've been trying to be there, but I'm glad you can hear me at least.
You might want to. I feel like Zoom has been having issues all week. You might want to log on and log off, log back on, and if that doesn't work, then maybe we'll just have you.
I've tried it several times, but as long as you can hear me, that's fine. I can see you, and this way I can eat my lunch without embarrassing myself.
Okay, sounds good then. Thank you so much.
All right, thank you.
Great. So then
right.
I think that's I don't see any other members of the public.
Okay, so let's go ahead and get started with the first item, which is the agenda, the meeting summary approval and the action items from the May 19th, 2022 meeting. Does anybody have any comments or changes to that summary? Okay. Do we have a motion?
Catherine moves.
I'll second.
Okay,
I'll do roll call. Al-Saraf,
yes.
Whitemaster, Bennett,
Yes.
Blakemore,
Yes.
Bocelli, Bushelli? Oh,
Yes.
okay, great. Connolly, Meeker,
Yes.
motion passes.
Okay, great. So let's dive into our main discussion item, which is the recommendations relating to the definition of civil legal services, which was a working group that was comprised of myself and Catherine, and led by Chris McConkey, and with the input of a whole bunch of other folks on the staff side. So I'm going to turn it over to Chris to get started, and there's a lot to discuss. And Brady, want to note we got your feedback on the criminal issue, and I think that's something that we'll build in the discussion. I appreciate that feedback.
Yeah, I mean, would you like me to kind of present the overview?
If you could, that would be great.
Great. And Dwan and Amin, I had encouraged Disability Rights Education and Defense Fund, DREDF, which everyone else will remember from the meeting materials or will hear about, was our one legal services grantee. LAC wrote a letter providing feedback on the proposed definitions, and then DREDF was the one legal services grantee to write their own letter. And I encouraged them to join in case they wanted to make a public comment. So maybe we can just keep an eye out for them. Their comment was about the definition of civil. And that's actually going to be the second of the two definitions that I'll talk about. So if they join later, they might want to say something. Okay. Good afternoon, everyone. Happy Friday. Just as a reminder, I'm Chris McConkey, Program Supervisor in OA&I, and everything I'm presenting to you is the result of Dwan's and my work with Amin and Catherine. So this is really the working group, Amin and Catherine's terrific work product. I just get to take a lot of the credit by being the one to present the slides. The presentation, we have the luxury, I think, of having the full 2 to 3 hour meeting just on this one codification topic. I think originally we were going to share this meeting with another topic, so we actually have a little bit more time than we were originally thinking, which is good because there is the potential for a tiny bit of wordsmithing with the definition of civil specifically. So this presentation presents the proposed definition of legal services first. Of course, the committee can wordsmith that too if it likes, but that was the one where the community was pretty happy with how it was phrased. And then the definition of civil is the one where we had some feedback. So I'm going to do the definition of legal services first, but I'll do a quick background, talk about the focus group input process, the working group's thinking about the proposed definitions of legal services and civil. I'm going to encourage Dwan, Amin, and Catherine to just jump in whenever they feel like it, to add extra, to either add a nuance or just add more information. And then we do have a resolution for you at the end of the meeting. So for the proposed definitions of legal services and civil that was in today's materials, it's really helpful to just lay a foundation about why these two definitions are really, really fundamental to oh, sorry, getting a little bit of background noise. Oh, there we go. Perfect. So why they're really fundamental to award making. So the Business and Professions Code uses both terms, more or less right next to each other. I kind of think of it as 3 core pillars. These terms comprise 3 core pillars that sort of hold up all of these grants. The first pillar is it's fundamental to eligibility for Interest on Lawyers Trust Account and Equal Access Fund funding, and by extension, all the other grants like the homelessness prevention grants, which require eligibility for IOLTA and EAF funding. The terms appear in the definitions of QLSP and Support Center. So, for instance, quoting the statute, QLSP means a nonprofit project that provides as its primary purpose and function civil legal services without charge to indigent persons. Qualified Support Center has a similar definition. And if I see hands, I'm just going to call on them as I see them. So Jim, and you're on mute, Jim.
Sorry, indigent persons is that defined as 200% or 120% of federal poverty level?
It's it's a multi-pronged definition, but it's the 200% income threshold now, and then or like qualifies for Older Americans Act funded services and the like. Yeah.
Okay.
Thank you, Jim. And then QLSP, Qualified Support Center also references civil legal services and its eligibility. It's the second bullet point there. So it's core to who can even qualify for this funding. Also important to note that in the same section 6213 in the Business Professions Code, effective this last January, so calendar year 2022, the legislature now has civil legal services includes legal services related to expungements, record sealing, or clearance proceedings, not requiring a finding of factual innocence and infractions. Okay, so but that was pillar number one, eligibility. Pillar number two is it goes to what, so once someone is eligible, what can they spend the dollars on? Permissible activities, right? So section 6216, for instance, says the state bar shall distribute all monies received under the program for the provision of civil legal services to indigent persons. So it's one thing just to qualify for a grant. It's another thing is like, now that you have the grant, can you spend it on this or that? And then the third core pillar that kind of holds up the whole schema is how much money do you get? So for instance, 6216 also says the state bar shall, it's the funding formula, shall distribute funds for the county based upon the amount of the, for qualified legal services projects, total budget expended in the prior year for civil legal services. For support centers, it's a different formula that does not reference civil legal services, but for QLSPs, it determines the size of your award. So it's rather fundamental, which is why we need to define them very carefully. So going to the state bar, that's the statute, going to the state bar rules, there is a definition of legal services. There is not a definition of civil. So the definition of legal services that is in the rules for the trust fund program right now that the committee would be recommending an update to is, quote, legal services include all professional services provided by a licensee of the state bar and similar or complementary services of a law student or paralegal under the supervision and control of a licensee of the state bar in accordance with law. So it's very focused on licensure. And those who are under the control of those who are licensees of the state bar. Okay, so those were the authorities, right? That's what the statute says. That's what the state bar rules say. The endeavor is to see whether or not to update the state bar rules. So the working group and staff started looking at what could the definition of civil and what could the definition of legal services be? What is a good point of comparison? And the working group and staff gravitated towards the American Bar Association's definition of legal work that it uses in its standards for the provision of civil legal aid, which are of course the standards that the commission has adopted as its guide for evaluating the quality controls and quality of work for grantees. So it's not controlling, but we've already put so much weight on the ABA standards that it was a logical place to turn. Now, the ABA defines legal work for the purposes of its standards. It doesn't purport to, that this is the definition of legal work that everyone should adopt, but it's a really good one. And indeed, the definition that the working group and staff have recommended for the committee today bears a lot of similarities. And I took the liberty of bolding some of them. I think it's worth reading the definition in its entirety. So bear with me if this feels like it's dragging. Legal work refers to all of the work that involves the use of legal skills and knowledge that an organization performs on behalf of the low-income community it serves. It includes legal representation of individuals and groups. It also encompasses non-representational services and forms of assistance, such as community legal education and the provision of legal information, pro se clinics, and other forms of self-help assistance, as well as studies and reports on issues of general importance to the low-income communities served by the organization. Finally, it includes advocacy in legislative, administrative, and civic settings done on behalf of clients and or their communities. So comparing that to the definition of legal services that we have now, which is very focused on licensure and those under the control of licensees, and doesn't really give, I'll just tap back to it for a second, it's at the bottom of the slide, doesn't give any examples of what legal aid actually looks like, and is very specific to a particular professional license. The ABA definition focuses more on the low-income community, the rights of the low-income community, and what legal aid looks like. It talks about various forms of legal representation and non-representational services. It gives examples of things you might not immediately think of as traditional legal aid, but are very part and parcel to legal aid, like studies and reports on issues of general importance and advocacy in legislative, administrative, civic settings. So I bolded some of the things. I actually didn't mean to bold the such as, but I bolded some of the things that the working group and staff tried to carry forward in its either the proposed definition or its explanation of the definition in the memo. Because I know I talk fast, I'm just going to kind of pause for a moment, just because I don't know if Amin or Catherine or Dwan want to add anything, or if just you don't even have to raise your hand, you can just interrupt me. Okay, so wrapping up the background piece, getting to the recommendation. There was some public policy, including grant making considerations floating around in our heads. So just to say them out loud, the public policy considerations in defining legal services and civil was maybe first and foremost, how do we maximize access to civil? The definition needs to be conducive to or effectively maximize access to civil justice in the way that it directs rather finite public funding. Again, the definition gets at who is eligible for these grants. This, you know, the state of California has made only so much money available for public funds available for civil legal aid. Who can qualify for these grants, and then what can they spend the money on? So to make sure to maximize access to civil justice by directing the finite public funding towards the optimal uses, to avoid accidentally opening the door so wide that by accident, other types of nonprofits that no one would think of as legal aid programs might suddenly fall in the definition and apply, and the work that they do would suddenly qualify. We wanted to avoid that accidental opening of the door too far. While also still allowing an effective mix of strategies. So not shutting the door so much that that now only like representation by an attorney qualifies and nothing else does. So making sure that there's there's room for innovation and mixing strategies, and what sometimes programs like to call holistic services, but you know, it kind of like caveat that as still being legal services. And to otherwise uphold the legislature's intention in the statute. And then, of course, sort of at the ground level in our day-to-day work, to promote consistency in eligibility determinations year over year. The more specific and clear and helpful the definition is, the more consistent those determinations will be over a long period of time as commissioners come and go, as staff members come and go, to promote consistency in the technical assistance that staff gives programs, and to help the grantees themselves inform their services so that they would know with greater certainty that they were going to be able to count something, for instance, on their IOLTA application in the spring, and not discover at the last minute that they have to deduct it because it wasn't qualifying. The practice, we have that written definition. It's focused on licensure. It's one sentence. It's very short. It's not very specific. So practices have emerged to things that have sort of fallen in and fallen outside of, generally speaking, eligibility. So this table just sort of seeks to capture some of those practices. The proposed definition seeks to make these a little bit more clear as to whether or not they fall inside or outside the definition. So the practices have generally been civil legal representation information, et cetera, is generally included. I think probably almost always included, whereas criminal, column 2, defense work generally has not been included. There's the notable statutory exceptions now for infractions, expungements, record sealing, et cetera. Education and counseling that requires legal knowledge and skills as a matter of practice has generally been included, whereas education and counseling not requiring legal knowledge and skills has generally fallen outside of the definition in practice. Social worker services that advance a legal outcome in an underlying case, legal matter or case, the practice has been to count that as legal services. Social worker services not advancing a legal outcome in an underlying matter case has fallen outside. And direct public policy advocacy, aka direct lobbying, that benefits indigent Californians. So that would be lobbying direct for the grantee lobbies directly towards the legislature or an administrative setting, has fallen within the definition of legal services, whereas grassroots and mobilization work have generally fallen outside of it. So these are sort of broad general areas of inclusion and exclusion in practice. Yeah, Jim. I'm sorry, Jim, you're on mute again.
On the direct policy advocacy, I seem to remember some rule that it has to be at least 60% indigent. If it benefits both indigent as well as non-indigent populations.
Oh, I didn't run across that. It's not, to my knowledge, one of the written rules, one of the trust fund program. You know, like if you go look up like the state bar rules. Duan, do you remember? Was that a working definition?
I'm sorry, I missed that question.
So it's like, was there sort of a threshold where if direct public policy advocacy was going to benefit both indigent and non-indigent Californians, was there sort of like a numeric cutoff where it's like it needed to benefit at least 60%?
Well, in the context of the eligibility committee, EBR committee, they had said over 50%, but again, that wasn't codified. That was just a practice that we had adopted over the years. But,
I think, sorry, John.
no,
Finish.
go ahead, Catherine.
I was just going to say, when we do I recollect in doing the reporting to the bar about our work, and there's a specific report on public policy, that we had to show the impact being like kind of a primary purpose to benefit indigent Californians, and there's specific criteria about how did you reach that conclusion. So who benefits from the work, and how did you come up with that, like a majority or more than a majority of the individuals benefited from the work? So I think that's, I don't know if I remember something about 60%, but it's sort of that eligibility requirement of primary purpose benefits from indigent Californians.
That's right. And then the staff has discretion. And again, this isn't codified, but over office practice, if it's clear to us that's over 50%, then we can approve it. But if it's not clear to us, that's when it gets elevated to the committee. And then the committee has, in the last few years, have also adopted the disproportionate language. Like if it's not over 50% or it's not clearly over 50%, but the program can make an argument that it disproportionately impacts indigent clients, then it seems the committee has approved those. Well, it's a combination of everything that Catherine and I have said.
I was just questioning, what if the primary benefit of the policy is to help a particular group of people that may or may not majority be indigent, such as Native Americans or undocumented? I mean, would you have to prove that most undocumented are indigent, or?
No, you don't have to show that. If you can make a argument that even though maybe a lot of people benefit would be over 200%, but however, the people that would benefit that are less than 200% would be disproportionately benefit, then that could get you over the hump as well.
Okay.
I think the committee's been pretty careful. The eligibility committee, these questions have come up. And so I think there was some redistricting proposals based on the census and the people wanted to include that work, but there wasn't a way to say in a redistricting proposal that the majority of people in the district were indigent, because the data didn't support that. And so as I recollect, the eligibility committee did not allow the work related to the redistricting. So that's just an example of like sort of the analysis that went into it. And, staff is really helpful in sort of helping the committee look at the data.
And the topic on indigency is actually going to go before you next week. That's why we have a back-to-back meeting. Originally, we were going to present on both this topic, indigency and primary purpose at the same time, but it was too much in one meeting. So we had to split up the meetings.
Great. And as a matter of sort of like how this actually plays out on the ground, when they complete their ILAW reports, impact litigation and advocacy work reports, what usually happens is staff will flag like, oh, you did public policy advocacy to expand like broadband internet access to rural communities. We'll be like, that can benefit everybody. So we're going to need you to prepare like an argument for how it disproportionately, affects blah, blah, blah. And a lot of times programs will say like, you know what, like actually we're happy to just deduct that and save ourselves the time. And then those that are like, oh, great, yeah, I'd love to make an argument for that. It goes to the committee, and at that point, usually the grantee is prepared like a case, either some data that they've collected or an argument. and then the eligibility and budget review committee will look at it. And a lot of times they'll just actually deduct it because they don't want to make the argument, or they didn't spend very much money doing it. Like maybe they signed a letter or something like that. Okay, so that was the background. So the working group and staff convened 4 focus groups on the front end, really before even drafting the definitions. I think staff in the working group kind of had like like the ABA definition percolating in their heads. But we didn't like have a draft definition at this point to show the working groups, but we just kind of went into it with what the endeavor was, and asked for legal services grantees, a subset of legal services grantees, thinking about how open the door should be. Are there current practices that we're saying are legal services that they think maybe aren't really legal services? Sort of spoiler alert, not really. And are there things that aren't in the definition of legal services, the definition in practice of legal services that maybe should be explicitly permitted in a revised definition, and to otherwise share their thoughts. So we convened 4 focus groups. We kind of tried to cluster them sort of in the direction that we kind of wanted the conversations to go. So with some success, the one group was sort of focused more on grassroots versus direct public policy advocacy. And we also had some programs in there that had what we call rental assistance programs, which are essentially programs that have housing law legal services departments that might do eviction defense work, for instance. Also have programs where they administer, for instance, cash assistance to tenants. Of course, the cash, no one claims that the cash is itself legal aid, but sometimes it comes like, well, is the salary costs of some of the staff members of those rental assistance programs might that staff time sometimes be legal aid if they're, for instance, working with the legal services team on something. Maybe they're doing cross trainings or something. So those programs participated in that group. We had one for providers that have education and counseling services that could be legal or non-legal depending on the context. So a classic example is just health insurance counseling, or maybe like financial literacy education, where in a different context, they could not even have a legal issue. They just want to learn about what their health insurance options are, or more about financial vocabulary, or it could be instrumental to an underlying legal aid case. So it's kind of fact specific. We had one for providers that had staff social workers that assist with legal aid cases. And then after those 3, we decided to have one focused exclusively. We had some high cap health insurance counseling and advocacy program providers in that second bullet point, the providers with education and counseling group. We decided to have a breakout focus group just for them because we realized HACCP was actually a really kind of sophisticated, the boundary there was needed to be clearly defined. It's a rather sophisticated and statewide delivery structure, HICAP, as the memo gets into. And so we wanted a group just to talk to them. We aimed for about 6 to 8 programs per group. We aimed for more or less geographic and diversity within each group, and also different sized organizations. And then we were very lucky and happy to have the Legal Aid Association of California sit in on all 4 groups and participate. So the areas of agreement and disagreement that came out of the focus groups were actually quite influential in the crafting of the proposed definition. So it's worth going through them. This is in the memo, but essentially where there were areas of agreement, the working group and staff put quite a bit of weight on, like, the community seems to be pretty on board with this idea. And where there was disagreement, the working group looked a little more closely to actually take a position. So you might see some of these in the proposed definition. There was general agreement that the current definition, that one that's just like 1 sentence long, very focused on licensure, that it was too exclusive. It's sole focus on licensees and the people under the control and supervision of state bar licensees, kind of fails to capture the true breadth of the spectrum of professionals that actually provide or help to provide civil legal aid. That was an area of general agreement. It didn't include investigators, community advocates. It didn't include translators and social workers and that sort of thing. The definition, there was general agreement that the definition should have at its core the legal rights of low-income people. It makes no mention of their rights or their legal issues at all. It doesn't even mention indigent clients or the low-income communities. So that the revised definition of legal services for the purposes of the Legal Services Trust Fund program should have at its core the legal rights of low-income people, since it is the work of legal aid and support centers to create, advance, and defend those rights. There was general agreement that if too broad, the definition was too broad, organizations with only a peripheral connection to legal aid might suddenly overnight qualify for funding and start to apply for these grants. And then if found eligible, would be able to use those dollars on the work that they normally do that might be quote unquote peripheral to legal aid. And so just to be very careful in how we draw the boundaries of the definition. But of course, it needs to agree with the legislature's intention for the OPA statute. And there was general agreement that there should continue to be room for complementary services. And that's actually a term that the ABA definition uses, complementary services, which in practice is already allowed. Those are things like social worker services when they're advancing a legal outcome in an underlying legal aid case or matter. So that the general consensus was there should continue to be room for that, at least when it advances traditional legal aid. Because there are nonprofits out there that just have only social workers on staff and no attorneys and don't even think of themselves as legal aid providers. So there wasn't consensus that they should suddenly be called legal aid organizations, but that that when advancing legal aid, that those should be continued to be called legal services. And then 3 areas where there seemed to be different opinions. So one was whether or not grassroots work, grassroots lobbying, and mobilization. So mobilization would be like encouraging people to register to vote or to complete the census or something like that. Lobbying would be asking members of the community to contact their own legislator and to vote and tell them to vote yes or no on a bill, for instance. Grassroots lobbying and mobilization, whether that should count. We had at least one provider that made a very good case that it can serve as a very meaningful, very impactful form of legal aid community engagement, getting them engaged in their legal rights and exercising their rights, for like empowering them and educating them about their legal rights in the law. There were also opinions, and in the end, staff in the working group shared these other opinions, that attorneys aren't really necessary for a lot of grassroots lobbying and mobilization work, kind of like get out the vote type work. And a lot of non-legal aid providers do that work. And if they all suddenly are considered legal services providers, they will all become eligible for IOLTA funding and could spread that funding more thinly. There was different opinions about how to define complementary services like those of social workers, that doing so too broadly could open the door to non-legal services agencies that have maybe only, for instance, social workers on staff, or do only sort of complementary services, but don't have any attorneys on staff. So where to sort of, how to keep it connected to legal aid. And then there was one suggestion that I think kind of it came to the surface for a moment, but it was pretty quickly, I think the community kind of moved past it pretty quickly, of maybe having 2 definitions, one that's narrower and tighter to kind of get through the door to qualify for funding, and then a broader one that once you're through the door, now you can spend the dollars on more things. The 2 reasons why that didn't really stick was, one is it would become confusing, people thought, to have to future commissioners, to future grantee staff, to future state bar staff, which definition applies when. Are we doing the narrow one now and the broad one later? And but also it seems like it might be at odds with what the legislature intended. When it uses the term legal services in the OPA statute, it doesn't suggest that it means 2 different things. I said one pillar in the definitions of QLSP and support center says civil legal services. And then another pillar, it says the state bar shall distribute these funds for civil legal services. There's no suggestion that it meant for those to mean different things. Okay, Jim.
Yes, but we do have 2 different definitions for indigency. So I think if people can handle that, I don't see why they couldn't handle this.
Oh, you mean it's like a practical matter, like it could be operationalized. Yeah. I don't want to have like too little faith in like future commissioners and staff. Like maybe if there were 2 definitions, people could keep them in their heads and know which one to apply when. I think what I heard more was people were like, I don't know if the legislature meant to like have a really strict doorway, but then once you're in, you can spend it on other things that wouldn't have qualified for eligibility, but now qualify for dollars spent. I feel like people felt like that was unstable footing. And then as a practical matter, there was a question of like, would it also get confusing? Okay, so the next slide actually has the definition, but I'm just going to walk you through sort of like what was really like what felt compelling to staff in the working group. So in proposing the revised definition, the working group kind of and staff started out hoping to capture more or less the definition of legal services that's in practice, not the one that's written out, but like this is currently allowed, this has been excluded over time, years over years, grantees have gotten used to this, there's a precedent for it, to really try and capture what the current practice is, unless there's a good and obvious reason for drawing the boundary that now something is out. So we did seek to keep in place the activities that we've been calling legal services as part of the definition, and to otherwise become more specific by clarifying and really guiding the grantees and the definition by providing examples and using more specific language, and generally moving away from the emphasis on licensure and more towards activities. In that spirit, it also attempts to address some ambiguities in the current written definition around legal aid that social workers assist in providing and public policy advocacy. The proposed definition is grounded in the legal rights of indigent clients, like the ABA definition of legal work is, and like the focus groups encouraged the working group to do. It incorporates elements of the ABA's definition, such as by providing examples, by taking on policy advocacy directly, discussing reports and studies. It categorizes legal services in 3 ways. So the ABA definition refers to legal representation and non-representational services, 1 and 2. The proposed definition that the working group wrote has 3 categories: legal representation, non-representational services, and then complementary services, like social worker services. The proposed definition requires an attorney to perform or supervise representation and non-representational services, much like the current written definition does. It does not require an attorney to supervise or perform complementary services, but rather to direct them. And the memo goes into the semantic difference between supervise and direct. So it's a long slide. I query whether or not it's actually helpful to read this out loud. If somebody wants me to read the slide out loud, I'm more than happy to do it. But instead, what I'll do is I'll just touch on the things I bolded. Well, does anybody want me to read it out loud? Everyone got the memo, right? I'm not seeing anyone nodding their heads. Great. So what I'll do is I'll leave it up for a little bit. I'll assume you've read it. Let me know if you want me to read it. But what I'll do is I'll touch on the things I bolded, because those are the things that I wanted to say something about. But this is the proposed definition of legal services. It's much longer than the 1 sentence. That was purposeful. We are moving in the direction of trying to be like giving more guidance, clarifying ambiguities, and that can look like at times providing examples. So the emphases that I would offer are these. So obviously the bolded language is just bolded on this slide, not in the definition. So the focus here is legal services means, instead of saying any services that a licensee provides, or however it was worded in the current rule, professional services of a licensee. Instead, it now moves towards work that uses legal knowledge and skills to create, advance, protect, or enforce the legal rights of indigent clients or communities. So when you read through the memo and you sort of see how the proposed definition applies to all those applications, a lot of it hinges on whether or not, in those examples, it uses legal knowledge and skills to create, advance, protect, or enforce the legal rights of indigent clients or communities. It goes on to discuss examples of legal representation and non-representational services. I broke it up into bullet points here to just kind of, because for logical flow. So like this is all 1 paragraph in the proposed definition, but the second bullet point is essentially like the examples of non-representational services. It gives these examples. These were areas of ambiguity before. Now they would become explicit. The one thing I bolded in the second bullet point was the working group and staff used the word directly in discussing advocacy towards government bodies, and they go on to explain in the memo that they do mean direct policy advocacy, not grassroots policy advocacy. That captures the current practice of allowing direct advocacy from a grantee towards lawmakers on indigent communities as legal rights. It keeps that in the definition, and says that grassroots work, if you're going out and asking members of the community to advocate for themselves by calling, you doing like a phone-a-thon or a letter writing campaign where you're getting community members to write to their member of Congress or something, that would be outside the definition. A lot of nonprofits do that work. They don't have any attorneys on staff. They don't think of themselves as legal services providers. And the idea was not to suddenly make them legal aid programs. The third bullet point specifies that representation, non-representation services must be performed or supervised by an attorney. There was a lot of agreement that something like this needed to be in the definition. The current one references licensees and those under the control and supervision of licensees. This sort of seeks to capture that, like, attorneys, to avoid the unauthorized practice of law, and as another sort of like a thing to look for to see if something is legal versus non-legal. Is it something that an attorney needs to be supervising or performing? And then the last bullet point is the exception to that. It's also an exception that's in current practice, which is for complementary services, like those that social workers perform. An attorney may not actually be the expert in the delivery of those particular services. We didn't want those services to be categorically removed from the definition of legal services, like they will never count towards your eligibility. You can never use your IELTS dollars on them. We wanted that to still be possible, but it needed to have a very strong connection to a legal aid case or matter. And the way the working group approached it, after speaking with the focus group attendees, was that a legal aid attorney should be, I'll just go in order actually, as like 3 elements. So the complementary service provided that it advances a legal outcome as opposed to a non-legal outcome in an underlying case. So for instance, the social worker is helping to interview a client, and they're doing it in a way that is trauma informed, and it's to help the client or the attorney prepare for court or to create a case file. That's clearly advancing a legal outcome. If the non-attorney staff member is helping to provide healthcare services, maybe English language skills or something like that, that would be advancing like a healthcare or like linguistic outcome of a case as opposed to like the legal outcome of a case. So the memo draws a distinction. It must serve as an integral part of the attorney's strategy in the legal matter case, and the attorney must direct the work. And the idea behind direct was the attorney needs to be the person who says, I authorize this complementary service as a component, a strategy in this case that I am working on, and can likewise direct its exclusion from that case. The attorney doesn't need to be the one providing it or even supervising the professional, if indeed the professional actually has more expertise in the provision of that complementary service than the attorney does. It may be inappropriate for the attorney to tell them how to do their job, but the attorney should be the one to authorize the integration of that complementary service in the case. If at any point the complementary service comes into conflict with the attorney-client relationship, or otherwise like jeopardizes the case in some way, then its legal services nature would fall away. It wouldn't enjoy that status anymore. So the next slide just kind of gets it gets to like the feedback we got from LAC, and I'm wary of like going too quickly, but I will pause for a second, just see if anyone had any questions about anything they read in the memo as far as the definition of legal services go, because I'm going to talk about the definition of civil in a moment.
Yeah, if I could make a comment for a second, if you can hear me.
Yeah, please.
I'm concerned that we might be stating these a little bit too tightly. The sort of the modern movement, one of the modern movements of legal services is to take a holistic approach. So you're not actually dividing up matters in a way that perhaps is suggested here. The idea isn't that there's a legal outcome and separately there's a health outcome and something else, but the idea is to serve the whole interest of somebody coming to the office. Now, I fully agree that if all you're doing is health services, that isn't legal services. But I wonder if what you're doing is you're providing a holistic process that includes legal services, and in conjunction with that, health services. Might not simply be to help the lawyer interview somebody, but to take the example, you have a domestic violence victim comes in, you help them with the legal process. You also help deal with the health issues that arise. That doesn't strike me as being inconsistent, as long as the holistic approach includes legal. Another example would be grassroots issues. I agree that generic grassroots, unrelated to anything legal, would not be connected. But I'm again concerned that we're being too tight in our definition. I'll give an example. One grassroots effort is groups that go out trying to organize tenants. And as part of that, the ultimate goal would be, for example, to convince a local entity to adopt a good cause requirement before somebody's evicted, or simply to organize housing projects so tenants can exercise self-help and seek their rights. It isn't necessarily something that would be directly supervised or directed by a lawyer, but I can imagine it would be part of an overall strategy, which included strictly legal aspects, but these other aspects also. And again, if all you're doing is just the organizing part and there's no legal component as part of the overall strategy, I would agree that should be excluded. So what I guess what I'm suggesting is it is more important that the non-legal portion of the work be part of an overall strategy that includes legal representation than it is to parse it out and say simply that this activity is no good and that activity is no good.
Can I jump in real quick, and then I'll invite, and Catherine, is it for the first one? That was great. Thank you, Judge Slickman. That was really helpful. And what I kind of recall because you had given two examples. One was like maybe healthcare services in conjunction with legal aid, and I'm so sorry if I like sort of misphrase what you said, but I think what you might have had in mind was like holistically, the healthcare services might actually increase their ability to participate in their legal aid case, or something like there's a connection.
Actually, no.
Okay.
Because if it is that, it clearly comes under your definition, I think.
Yeah.
I'm talking about what they do is you come to our office, the legal aid of whatever, or the domestic violence center, and we're going to deal with the entire holistic set of issues that arise from domestic violence. And that's legal, it's health, it's resource. And we're going to do all of them together because we can't ignore one component for the other. Because if you ignore the health part, you can have a great legal result and the person is totally a mess. So what I'm suggesting is that in that example, that the health services, somebody who is on staff doing health services, might actually not be directly related per se to the legal claim, but it's part of the overall package of relief that entity is providing.
Yeah. So the working group and staff, they wanted, their recommendation is to take anything that's not that even, but for like the legal aid case, like if another organization was doing it, there was no attorney involved, it wasn't a legal issue, still call that a non-legal service, right? If that like MFT services or other types of like case management, or maybe like the domestic violence center is also providing housing, temporary shelter or something, that wouldn't suddenly become a legal service just because the person had a legal issue. So yeah, that's, I think you've interpreted it correctly, and that would, I think staff would recommend against that. But I see Brady, and then I think Catherine, you'd unmuted yourself for a moment, so I'll turn it over to my betters. Maybe Brady, your hand is still up.
Yeah, I think it's a great point and a great observation that sort of the holistic approach has been taken. I think that the danger is we need a dividing line. We are stuck with the statute, and we have to consider what the legislature would want. Remember, this is attorneys paying for this, and attorneys' clients through their IOLTA funding. And you could imagine that if you, not that this distinction is necessarily the perfect one, but if you get rid of this distinction, you could imagine a one-stop shop where they're providing Medicaid services and comprehensive healthcare services that are funded by Medicaid. You could easily imagine an organization providing those sorts of services. If that was all counted as civil legal services, it would essentially swallow this program and thin out the resources dedicated to what's traditionally and agreed as legal services. So I think that's sort of the countervailing consideration.
Oh, and I appreciate that argument, which is why I made a second point, which is separate and apart from my first quote holistic. I think that it would be useful to be the focus here is the overall legal strategy. And I mentioned the example of organizing, that I can see organizing, which may be standing alone, not connected with any legal strategy, would appropriately not be considered civil legal services. But I could also imagine a lot of organizing separate from direct advocacy to a governmental entity, which certainly would serve a broader legal strategy. And I'm concerned that maybe we are being too strict in how we look at that. And a lot of organizations, and I recall years ago when I was on the board at CRLA, they would have local advocates go out in the field to talk to farm workers, not only about their legal rights, but about organizing and to leadership development and matters which ultimately served the legal strategy of enhancing their legal rights. But I'm concerned that they might not be considered appropriate under this standard.
Yeah, I think that no, it's a valid concern. Just looking at it, and I think what the memo says is when it comes to stuff like grassroots advocacy, if there's a component, and this won't necessarily, I think, address your concern, but I think just so everyone remembers where the boundary is drawn in the memo, I think it says like, if you're doing grassroots work, if there's a piece that does use legal knowledge and skills, like your part of your grassroots advocacy is educating someone like about what their legal rights are, like that piece is, in, but everything else is carved out. So that, right, that's kind of where the memo drew the line. Okay, I know Will and Jim had their hands up for a while, but I can't remember who raised them first. So maybe Will, because you haven't had a chance to go yet.
I think it was Jim, but that's okay. I have a lot of thoughts, and this is really I think a grand improvement. So thank you for all of your work. But to jump on what Judge Seligman said about the advocacy piece, and I'm unclear, would something like publishing on your own website or making available flaws that you see with the law and changes that you think would be beneficial fall outside of this definition, because it's not advocating directly to government bodies, it's publicly stating a position on changes in the law? Or would, for example, consulting with a nonprofit on those same things? What are your recommendations? Because I don't believe laymen are going to be very effective at, one, understanding the totality of the law, and two, clearly advocating for what changes are needed without a lawyer somewhere in that process. So under the proposed rule, how would those pieces fit?
I think your first one, and I kind of missed the second one, but the first one was like just putting information out there in the world, say, for example, on your website. Like, we think this law could be better. That probably fits neatly under this definition. It could go under the first sentence. The legal services means work that uses legal knowledge or skills. So you're exercising your legal knowledge or skills. You could say that just putting it on your website and like messaging it to the world, to the media, to policymakers who check your website, would help to create, advance, protect, or enforce legal rights. And then or it could go under the an example of a non-representational service providing legal information, advice, trainings, and self-help resources. That first one I think kind of fits neatly. I'm sorry, I kind of missed your second one.
Sure.
Yeah.
So if you were a nonprofit was doing advocacy work for indigent populations, and as part of building a strategy for effectively advocating for either changes in the law or advocating to certain politicians or whatever, they consulted, it seems like it would not fit here as I read it.
I mean, I'll let like Amin or Catherine, if they think it fits. I think that could still go under the first one, it using legal knowledge or skills to create, advance, or protect.
To me, it falls like, if I think of this like in the work that my program when I was there did, like we would develop a public policy position statement that would sort of say, here's the pros and cons of here's what's working well, here's not what's working well. And all of that went on our website. And I view that as like advancing or enforcing, rights. So to me, if you're developing a proposal that says, here's something that works okay in the law and here's ways to improve it, that's advancing the legal rights. And you could include it under that. And it's also work that I think leads often to the direct lobbying, because you're going to use that then to inform, policymakers and so forth.
Okay, I think that helps a lot. I think where I got tripped up was because you used the phrase advocating directly to government bodies. I took it as exclusive, and I realized, reading the whole rest of it, it could probably fit, and that doesn't mean that you can advocate, you only can advocate directly to government bodies. You could advocate to other nonprofits in the service arena, as I understand it now.
I think that's correct. That's just one person. I think that's right. But me and Catherine, if you disagree. So but you raise an interesting point that about sort of like the way the proposed definition is structured. So it may be helpful, it may not be helpful that I broke it up into bullet points, but the first sentence sort of establishes like a very broad way to get in. Like legal service means work that uses legal knowledge and skills that creates advances, ... Like, end of sentence, most of it will get in that way. And then it goes on to clarify this is both legal representation and non-representation, and it gives a bunch of examples. I think the list of examples is not meant to be exclusive. That's why it says like examples include. So to what you just said, Will, yeah, the directly is an example of directly towards government bodies is an example of something that would be a non-representational service, not meant to be exclusive of other things. But the memo does lay out the working groups and staff's case for excluding, and this gets back to Judge Seligman's concern, excluding, which I didn't mean to actually move away from, grassroots work that would involve asking the members of the community to themselves contact like their members of the legislature. The memo does lay out the case that was deliberately excluded from the draft definition, and the word directly was used on purpose. I mean,
I just want to point out, and sorry, Jim, I know you've been waiting patiently, but I just want to sort of point out, this both you, Judge Seligman, and Will are raising issues that were at the core of our discussions and at the core of kind of our goal, which was to figure out a way to sort of balance this concept of, supporting holistic services, supporting, the kind of wraparound efforts that a lot of these organizations are doing while still maintaining consistency, as Brady brought up, consistency with the goal and the sort of structure of what the funding is meant to be used for the legislature. And so, and it's not easy, and condensing it into a specific definition, there's a lot of like wordsmithing gymnastics, and the purpose of this discussion now is to sort of solicit any further input on that level. The memo, which will be something that will be available and is meant to sort of help further kind of clarify all of this, goes into a lot of depth and has, a lot of analysis of these particular types of situations. So there's a whole section on grassroots mobilization, and then a kind of a summary chart that lays it out a little bit more clearly. This is for grassroots, for example, or high cap, or some of these other sorts of issues. This is what we mean would be included, and this is what wouldn't be included as examples, because this will come up, and this is going to come up constantly throughout, most likely. Our goal was, again, to be as inclusive as possible without straying too far away from, what the funding is meant to be used for. So I just want to highlight that because, Chris and staff spent a lot of time developing this memo and putting a lot of thought and analysis into the explanation and examples. And, to the extent that there's more that we would want to add to that to clarify specific examples, specific issues that might come up, just to make sure that we're kind of being as inclusive as possible. Let's discuss that.
And then Jim, because I'm doing way too much of the talking. I think it was Jim and then Pamela.
My question is on the representation bullet point. I presume when you say representation, you mean legal representation, which means you have to be licensed. And you don't say that, but given your examples of non-representation, that's how I interpreted it. And what I'm concerned about is the Access to Justice Commission has been examining alternative programs or means of delivering or increasing access. And one of the things we've been looking at is the New York Legal Navigator program. And Catherine probably knows more about it than I do. But what I'm concerned about is on that representation bullet point, it says must be performed or supervised by an attorney. And as I understand the Navigator projects, the legal service provider attorneys would probably train the navigators, recruit the navigators, monitor the navigators, but they're not directly involved in supervising each and every client and their legal need that the navigator works on. And so would this exclude that?
Well, I'm unsure like with how the Navigator program works. If the Navigator program works kind of like a law clerk or a law student or a paralegal, at a legal aid provider, the attorney might not need to participate very much. And they have to train the person and they have to have safeguards in place to make sure there's no unauthorized practice of law and should have eyes on each case. But it's conceivable that a non-attorney could be trained up so well and like pass so many like safeguards, sort of like check all the boxes that they could do a lot of work by themselves with the attorney having more of a step back role, but they would still be supervising at some point at the end of the day. So I don't know if that's how the Navigator program works, but you're right. This definition would require an attorney to be involved at some level. Maybe they have to sign off on the case closing. They make sure the correct advice was provided or something. They couldn't just train and then never come back.
I think that comes up in the context of in the application that programs submit to for trust fund eligible services, which is what we're talking about. We're not talking about everything a program might do, but we're talking about what are the services that you say are qualifying. You have to explain your supervision structure so that your services are supervised by a lawyer, particularly the representation kinds of services. So that what Chris said seems consistent with the bar's approach of ensuring effective legal oversight of the work, while not trying to say a lawyer has to, be involved in every case. And I think for navigators, it depends on which model you're using. There's some navigator programs that are actually operated by courts, and the function isn't as much to give people legal advice about their case, but help them get to the right place in the courthouse so their legal issue can be addressed, where other navigator programs or something similar actually have somebody in court who's assisting you in court about how you're presenting your case. And I think there's maybe different nuances about the level of supervision and support that would be required in the first model. If you're helping somebody find their way around a courthouse, is that a legal service or not? And if you're helping somebody in court present their best case, then what kind of supervision do you need? Because that seems more clearly like a legal service, at least to me.
That's a great point, Catherine. Yeah, that's perfect. We like the level of supervision that's required is like context specific. So if the role the non-attorney is performing is very low risk for unauthorized practice of law, mostly provision of legal information, not advice, that kind of thing. Conceivably a grantee could just put in their application, we will use some of this for housing navigators or court navigators or something. This is what the work is that they'll be doing. The attorney will have this level of supervision. It could be very light touch versus we would expect to see a much heavier touch if it was, they were going to be doing more of like the provision of more work that looks like practice of law. I thought, Jim, you were actually going to ask about legal paraprofessionals because the state bar is also investigating whether or not to endorse legal paraprofessionals, and technically I don't know if they will be called attorneys or not, and this rule would seem to exclude them by its. But that was something that we did look at, and we just figured like this rule could be easily updated if it needed to include like a new class of licensure. Something like that would be an easy, like supervised by an attorney or a legal professional, right? But we didn't want to include it because that program is still being looked at by the Board of Trustees. Pamela, you've waited so long. I'm sorry.
That's okay. I just had a quick question about the word complementary and that and how it's used here. And would that be a way to revise or open the door to previously denied activities? So my major concern with the piece was the word complementary and what that really looked like, and would that reopen doors for activities that were previously denied?
That's a really great question, Pamela. Thank you for asking it. Right. So there's the three prongs: representation, non-representation, and complementary. The ABA definition doesn't even wade into the complementary waters, maybe because it was like too uncharted. They just stick with legal representation, non-representation. And then we added, the working group and staff added the complementary services because we felt like it would, mostly because the examples of social workers was so compelling. And it's so very much the practice to count that when they're working on a legal aid case. And we didn't want to, I think the original draft we looked at, we didn't have complementary services. I think we just called out social worker services specifically and left it at that. And we wanted to leave the door open. If this is a fair characterization, I mean, Catherine, feel free to disagree with this characterization. We wanted to leave the door open for other types of complementary services that might come up in the future. So it was an attempt to not write a definition that was so exclusive that someone couldn't make a good pitch. They would have to make this pitch in their like annual application where they actually say, I think this spending would qualified or doesn't qualify, or this proposed use of our funds qualifies or doesn't qualify. They could make a pitch for a different kind of non-attorney professional who will be involved in a legal aid case. And it could come in under where the attorney wouldn't be supervising that person because of like the unique expertise they have, but they could come in under the complementary services prong. So Pamela, it's a great question. I don't actually know the answer. If maybe there'll be something unforeseen that now sneaks in, and we would have wished that we had written this kind of third prong more narrowly. But maybe Amin and Catherine aren't. I don't know if maybe you didn't have that concern.
I mean,
go ahead. Yeah, Catherine.
I was just gonna say, I think it was generally designed to be clearer about the work that programs are currently reporting sometimes, and which the Trust Fund Eligibility and Budget Review Committee and the Full Trust Commission has allowed. So sometimes it's a social worker. Some programs have used, I think, psychologists to perform a somewhat similar role of a social worker in a case, getting someone to be able to testify in a way, elicit information from them in a trauma-informed way. So I think it's generally designed, to Pamela's point, to incorporate the work that we have. But yes, it's always possible someone will say, and now we're doing this other piece, and here's how it fits within that definition.
Yeah, I agree with that. I think the work group was largely trying to codify office practice, and then where there was a bit more confusion, to clarify that and then come down one way or another. And that's why, that grassroots piece, just refining that a bit. But we're not trying to deviate that dramatically from what's being approved and not approved right now.
I think something that kind of acts as a bit of a safeguard on this third prong, this third type of service, is because it has to have it has to meet these three elements: advance a legal outcome, which again gets at Judge Seligman has concern about that, but that prong, the integral part of an attorney strategy in a legal matter case. So like an underlying legal aid case exists, and the attorney is directing its inclusion as part of like the scope of strategies, acts as at least a soft safeguard on like something that's totally out there getting in. It would have to meet all three of those things. and still, and to be a complementary service. And it's still conceivable that maybe, oh, maybe we didn't want to include that thing, but it might be, you know it when you see it. Will.
Thank you. So I have two quick points. One is I have so many more questions about the application, but I think there's probably more in the presentation where that gets covered. So I wondered if I should just hold off on those as we go through.
Actually, I tried to keep, no, this is the perfect time. The next slide goes
Okay.
into the definition of civil, or it's feedback from LAC, and then it's the definition of civil.
Okay, maybe it would still be helpful to hear that. My second point was on the examples. And I think the reason I got confused was I read it as, if you're saying advocating directly to government bodies, it means indirect advocacy is not included. And so publishing on your website or consulting with groups that are going to go out and do that advocacy would not qualify. And just to be clear, I agree with the sentiment that we shouldn't be funding grassroots efforts like just generally. That is for others, but the experts in what is needed in the law are often the QLSPs, and allowing them to consult seems sensible. So I think it makes sense to have the response was it's covered by that first sentence. I think that makes a lot of sense. But then it makes me wonder, is it good to have the examples in here codified into the rule if it could potentially cause confusion?
It looks exclusionary or exclusive. It gives you, it kind of gives you appearance that like if it's not listed, it was meant to be excluded.
Right, or as you did, highlighting directly means indirect isn't included. This is, I guess, a small thing, but I feel like it could become confusing at some point.
This is what it's all about. This is like, how do you word it? It's all, that's the project, right? How do you word it? So, go ahead, Juan. Oh, someone, or maybe it was Catherine. I accidentally interrupted.
Nope, you did not. Sorry, I should just be muted.
Oh, that's right. Well, so that's great. So all I can do, Will, is I'll kind of briefly like walk you through with the working groups, like the evolution of this phrasing. So that you're right. That first sentence is how that gets in. That thing you're like, this is kind of important. They should be able to put it on their website. This is kind of like indirect forms of advocacy, right? Other nonprofits should be able to consult with them about the legal needs and rights of the low-income community and how the law could be improved. That I think gets into that first sentence. The advocates using their legal knowledge and skills to do that work. And then, right, the second bullet pointer, like it's meant to be a non-exclusive list of examples, and yet the word directly is there. So what I'll give you is this. I could be misremembering. I think we looked at whether or not to put in a sentence. I'm pretty sure there was originally a definition that we looked at that said grassroots lobbying is excluded, like more or less in those terms, and we took it out. What we did instead is we had a list of examples that we didn't mean to be exclusive, of things that definitely are included. Like we wanted to make sure direct lobbying was mentioned because it was an area of ambiguity under the old definition. We wanted to make sure it was like safe. So we included it.
Okay.
Used the word directly because we knew that was like, we wanted that to be safe.
Okay.
And then we just put in the memo explaining the proposed definition that staff in the working group thought that an application of this definition would be that grassroots mobilization, grassroots lobbying, generally would not meet the proposed definition, that first sentence. And I can't quite remember the reasoning, but we wrote out like what the reasoning was, how we thought it applied and why it didn't get in. And there was like one exception, which was if there is a situation where they're using in grassroots mobilization work, where they are using their legal knowledge and skills, like they're helping the community understand its legal rights, that's in. Because that you can almost break that away.
Page 15, where that chart is, that I think is helpful because it gives sort of in one place those examples. And I don't know if you have the chart on your slide somewhere or whether it's just people should look at the materials.
I don't have it on the slide, but I do have it I can switch the screen share.
Yeah, I just think, I feel like those, like the committee's effort to try and explain more what some of those examples were I think is there. So,
Yeah.
Yeah,
So
I
it's-
look at page 13 has like the
sorry, mine's on.
narrative part of the grassroots, and then 15 gets into the chart, which I think is, yeah, it's very helpful.
So, well, I guess I would sum it up as, we originally looked at whether to have a sentence that said grassroots is excluded, and it was pretty quickly removed. I think it was like, let's not go there. Let's say definitely direct lobbying is included, because we did mean for that direct policy advocacy is like definitely in bounds. Let's just say that so it's not ambiguous anymore. Let's address the grassroots in the memo. And I think where staff and the working group came down on it on page 13, it sounds like pages 13 and 15, was the working group and staff don't think that it gets in under the like legal services means work that uses legal knowledge and skills. I think it's insufficient uses legal knowledge and skills, but there's like, but if it does use legal knowledge and skills, like they're training the community, like going out to low-income communities and saying these are your legal rights, that piece that gets in, and that's almost just like a know your rights training. It's like for the same reason a know your rights training would qualify.
Right.
So they can, a applicant could make the case that like part of it qualifies. But the part maybe where they're like helping someone actually fill out the census or actually fill out the register to vote card or something, that part might not. It might be a case.
Totally agree with that. Yeah, I think that all makes sense. And reading through the memo, I agreed with that. It was just these edge cases that make me wary of including all of the examples for fear that a future staff would look at it and say, oh, well, that's excluded because you're advocating for a change in the law, but you're not doing it directly to the legislature, so it doesn't count.
Yeah.
But it's such a small issue, I guess, as long as it's perhaps noted in the memo or noted somewhere on the record, I suppose I'm willing to let it go. So, you know, I hope it doesn't preclude that in the future.
It's a super important one. There are, I think the grassroots work is a minority, a very small minority of programs, but they feel very strongly about it. Like it's very important to them that they be able to continue to do that work, whether it becomes inbounds or stays out of bounds. I think though, you know, Judge Seligman's sort of question about like holistic services, and that one is, I think, more programs would be interested to know like where the committee decides to come down on that one. That like your issue that was like a small but mighty like subset of programs. Yeah, I think a lot of programs are very interested in, at least academically, in like, can we do holistic services? Because they all love that idea. But I think what we heard in the focus groups was there seemed to be a sense that like legal had a meaning in the dictionary, and you'll notice the memo never actually pulls a dictionary definition. That was more or less purposeful. We didn't feel like that was controlling, but like there seemed to be a sense that like it has an everyday meaning, and that there's some examples where like it doesn't really like seem to meet the reasonable or the everyday meaning of legal anymore. I think we talked in the working group meetings a little bit about, and some of the focus groups like, with like MFT, marriage family therapy services that were like directly, there is an underlying legal aid case, right? And like it's helping the client maybe participate in their case. Like where's the line, or maybe a certain type of healthcare service that's helping promote their participation in the case in some way. Is there a line? Because at a certain point, the services don't really look legal anymore. Obviously, yes, social workers that are helping interview a client right before they go into the courtroom, or helping to get them ready to avoid like a traumatic experience or something, like that's pretty clearly legal services. It's like in the courthouse. But it's fuzzy, right? You can keep making the case that something might help them participate in their case and increase the chances of a positive outcome in the case, but it stops looking like a legal service. And there seemed to be a sense that like whatever definition we have should, at the end of the day, sort of comport with like most people's working in their heads definition of what legal means.
So I think where I landed on this is, so we are required to say these are legal services, and we're trying to both take the work that's been done over the decades about what that breadth can be and move more in the direction of holistic, but always ground the greater breadth of services that are defined here within a definition of legal services. So, and I personally think that's a smart way to do it. I mean, the legislature has said it needs to be a legal service, and I think what constitutes a legal service can be broader in the way that we've defined it, but it has to be rooted in some way to a legal service. I appreciate always Judge Seligman's thinking. I'm not sure. I think it can be rooted in like a legal outcome, but has to be connected to legal services that's being done. And I think programs have become accustomed to, like, when you're working with your community, pulling out the pieces that are rooted in your legal right and the legal services that are being provided, and not counting services that go a bit further from that. And I think that's what this definition tries to do. So we may not have gotten it right, but that was what the attempt.
Oh, it's way closer to, it's way more friendly to holistic services than is the current definition.
Well, yeah,
It's like,
because that has
it's
to be
something
done.
an attorney has to do or something like that. Yeah.
No doubt, no doubt.
Yeah. At least that. I think maybe Jim and then Will. I'm never sure about the order. Yeah.
Whoever's on top is the order on your
Is
screen.
that really how it works? And I've
Yeah.
just been using Zoom for like 3 years now, and it's okay.
I'm telling you the rule, the insider's rule.
House rules, Jim, and then Will.
Catherine to the rescue.
My question is, I guess it relates to the second bullet, the last part on advocating directly for government bodies on issues of importance of legal rights, and more importantly, your graph on page 15, the last one where it talks about research and studies.
Mhm.
And I was just wondering, how does this relate, or how would the bar's last survey of California legal needs, would that qualify or not? Because, and I'm approaching this from a biased point of view as a social, or should say retired social scientist. I mean, I could see where a layperson would consider that survey of the California legal needs as social science research. But as an academic, it couldn't be published as social science research really, because it's got no theoretical basis. I mean, it's just collecting data, describing what people are saying is their legal needs and so on. So
I
How-
think
how is your group is-
in that collecting data, so that's the data to inform legal aid delivery.
So it would fund it?
It would fund that would be funded.
Because I
Because
know,
you're using that to inform legal aid. So if you look in that chart, including legal services, collecting data to inform, it says in-house, but to inform legal aid delivery. So like programs do a lot of work to understand the legal needs of their community. And that seems like a good precursor to providing effective legal services. And so informing legal aid delivery would be included.
okay, because I remember when they were proposing that, and originally they were saying that they were going to use IOLTA funds. And we objected to that on the Access to Justice Commission, as well as,
But I think that was the bar was going to use IOLTA funds. This is about the fund this is a little bit different, right, Jim? Because this is how can programs use their money, the money that they're given. That's the point of this.
Yeah, that's right. That controversy is about they
Bar
are
taking money.
not IOLTA, but it was bait grant settlement funds to
Uh.
fund the Justice Gap project. This is about, I think your question, Jim, is if a program was going to do another Justice Gap study, would that be funded? And I think what Catherine said, if they're tying that to the delivery of legal services, that gets them there.
Yeah.
And
But
it
it
would
would have to
strongly
be
think it's tied to
legal.
their delivery of, the community that they're serving. And then programs do this, like Advancing Justice did a study about where they should open their offices, and based on like the demographics and language needs and all that stuff. And we found that qualifying. And I would think under this definition, we'd still find activities like that qualifying.
Needs assessment type work, yeah.
But I don't think, I mean, just to be clear to Jim's point, I don't think this is trying to define how the bar can use IOLTA funds.
Yes,
This
this
is
is
a
ju-
definition
exactly.
of
Grantees, yeah.
This is just for our
how
grantees.
to use it. Mhm.
This is just for like what our grantees are, you know, applicants of IOLTA and EF funding, not the state bar. The state bar is not a recipient of IOLTA and EF funding. We administer, right? But we don't.
Okay.
Yeah. Am I successfully sharing the table now? Okay. I just
Yes,
wanna
you
make
are.
Sure. Yeah, and then Will, I didn't even realize that we had this on the table. I think Catherine tried to point this out, but there was the weird little carve out exception for the grassroots work. If it like involves educating indigent communities about their legal rights, like that would be in, because that's like a know your rights type work. Anyway, now that I see, this is the table we were all talking about.
Right, and consulting with a grassroots organization so that they were doing advocacy that mattered. That would also be in, as we discussed it.
I remembering back to your example from before, it was a yes. Yeah, and just like as time goes on, I'm like, my memory is fading as to the example you gave. But
That's
but
okay.
essentially, what I kind of remember you saying before was like, you know, they're providing their expertise about like the state of the law for low income people, like using their legal knowledge and skills to say like this is how the law could be better, and that kind of work I think would fit into the proposed definition of that first sentence. If a legal aid provider were itself providing that expertise, opining on how the law could be improved for indigent people's rights, or was otherwise wanted to use IOLTA, and then Amin, Catherine, Dewan, jump in if this doesn't sound right to you, but if they wanted to use some IOLTA dollars to acquire that expertise, like to in some way, that they could make a case that in their budget that would go in like contract, you know, services to programs or something like that, but they could try and make a case that would get reviewed when their budget is being reviewed, that was a qualifying expense. And I think it would be
I think
possible.
Will's question is about educating like other organizations in the community that serve indigent people.
I think
And
it's
in
fine.
my experience, legal aid programs can have as clients or people they do work with other organizations and consult with them about, but assuming that organization serves indigent people, right? So that's kind of the nexus, and I think that's what falls within that. So that, if I got
that
your
sounds
right,
safe to
then
me. Yeah.
Yeah, was that your question, Will, about organizations providing support to entities like? Yeah, and we
Right,
have
so
several
if a
programs.
grassroots organizations.
Yeah, we have several programs like Catherine mentioned that do provide legal assistance to like a nonprofit entity. But I mean, the threshold is those entities have to be helping indigent clients, you know, broadly speaking. So it can't just be any nonprofit. But yeah.
Yeah.
but you
Certainly,
could
I
take
think
a
that's
tenants' rights
awesome.
organization that was serving serving indigent people and provide legal advice about what those tenants' rights are, what are strategies to enforce those rights, all of those kinds of things. How does the law need to change to be better, right? What are
Yeah.
examples of a law that would be good to get passed in the local community to better protect tenants? All of that is an allowed cost, best I understand it.
Yeah, and it's never been controversial. That's always been very widely accepted that we qualify and we fund that work.
Well, that's awesome. I guess I was confused based
I
on
think-
reading the rule,
Yeah.
and
didn't-
if we can add it to the memo or whatever to make sure it's clear, because that's great work. You know, changing the structure can really help a lot of people effectively. So thank you for clarifying that.
Yeah, you know, that is a good point. Maybe we do add something, Chris, into the memo about you know, providing to entities, organizations, how we want to phrase it. It doesn't need to be in the rule itself, but in the memo. That I think that's
Yeah, what Catherine described was really enlightening and helpful to know that that's happening and that they can use it, that it can be a qualified expenditure.
Yeah, I finally understood your question, so my apologies for being not getting
No,
it.
it's
But somehow you
yeah, it's
said,
hard.
like, I got another community organization and people do that work. So I think that's fine to add something that clarifies that.
Great.
Excellent.
I think I've got that in my notes.
And I had a
Okay.
small question,
Yeah.
since I don't see another hand. And this is Can you clarify the difference in the first sentence between indigent clients or communities? I'm not sure I understand why that's there and what the distinction might be.
Well, the lazy answer is, I think we pulled that right from the ABA. I think the ABA's definition of legal
Okay.
services, indigent clients or communities. So that's where it started from, where it's sort of like we liked it. I think the idea was just that your illegal services can be work that uses legal knowledge and skills to create ... for a particular client or clients, or for an entire community that is indigent. So if you were going to take a case to improve the with the hope of improving the rights of like low-income veterans in general or something like that, that we meant for that to be included.
Gotcha. Okay.
Hi, this is Erica. So Chris, would that be sort of like the ILAW kind of stuff, the impact litigation?
Yes, ILAW, maybe in like a neighborhood that's particularly like low income or something. Then I'm making this up on the fly, so that this is haphazard of me. But like maybe there's like a particular public or private practice that's harming a very low income neighborhood or something like that, and you want to take a case that would benefit.
How about like payday loans, to give an example,
Oh, I love that.
right?
That's excellent.
Yeah.
That would be a case that you could bring on behalf of individuals and maybe some community organizations that serve low income people and see the impact that those practices are having. And that would be an example of a, work on behalf of a community in addition to the individual people.
Yeah, it strikes me that actually a fair amount of non-representational work would be more community-based than individual.
Right, because to establish an attorney-client relationship, you have to define your client, and that trends towards indigent clients rather than communities, probably.
Yeah,
I would agree with that.
It depends I don't know. People represent organizations that serve indigent people as a piece of the direct representation too, particularly in,
Yeah.
In a case that you might not want to get certified as a class, but you want to have a broader impact on. So choosing an organizational plaintiff would be a decent strategy. But anyway, we're getting away from what we need to do.
That's, yeah, sorry, I just was.
No. Good question.
Yeah.
The etymology is, I think it was in the ABA definition, and we're like, that sounds really good. Like, let's use that. So I think we pulled it in, and then it stayed because
I actually think it's helpful because at least in the eligibility budget review committee, like the ILAW stuff, we get a lot of these issues about, the impact on, what is the primary purpose, and like, is the impact primarily on indigent community? Like, so we deal with the community element a lot. So I think actually having communities in there is going to be very helpful. So I like having that phrase, that term in there to help us with our work.
So, but like I said, ILAW, the advocacy work part, the last two letters of the acronym, like that, a lot of the public policy work is usually like indigent communities is the thinking behind the grant, why the grantees are doing that thing.
Yeah.
So
exactly.
In terms of our process, should we, now that we've had this really robust discussion about this definition, should we be approving this definition and before we go to the civil part of it?
It's a great question. I'm going to probably defer to Dwan and Amin. My understanding is we can word the resolution differently than the way it was presented in the memo, because currently it's worded like approves the new definitions of civil and legal services. But hopefully this isn't what happens. But if the committee's like, we can approve legal services today, but not civil, like we could easily change that resolution to do the.
Oh yeah, I just was more like we have fresh in our mind what we've just finished talking about. Did it make sense to approve this part now before we got into the definition of civil? But I don't really feel strongly about it. It was really just a question.
So Brady, you can chime in, but I think you don't need to do it, but if you would like to do it that way, we certainly will oblige.
You can do two. Yeah, it's a discretion of like the.
So Amin, Amin.
I'll let Amin decide. And I think Will has a question too.
Let's take Will's, and just to give a sense, my thought is, yes, it's fresh, but I think it might be helpful to kind of work through all of the issues, and that might spark some thought on other things relevant to this definition before we get into actually solidifying the vote.
Okay.
But go ahead.
Okay. So I just wanted to make sure I ran down my list of questions. I am a little, the one that I got hung up on the most was when providing what I would call wraparound services like so therapy, for example, or helping with trauma. It seems to me what we are writing is, as long as you have a case, you can get some free therapy, but as soon as your case is settled, you're out the door and you're not getting any more services. And is that a correct interpretation, or am I missing something about the reality of legal work here?
Your
Because that would be
interpretation of the rule more or less aligns with mine. That bottom under complementary services, the 3 prongs. So for it to be in at all, even with while the underlying case was still active, it would have to be advancing a legal outcome.
Yeah.
But like, but what if it stops advancing a legal outcome, if the underlying case goes away, or it stops being an integral part of the attorney's case strategy, or the attorney otherwise directs stops directing that work be included, or it otherwise interferes with the attorney-client relationship, like any of those things, it would give way.
Right. Yeah, and I read that. It sounded really, let me tell you, if a therapist is recommending you stop cooperating with your attorney, there's some bad things going on there. But I also worry about the overall impact of that sort of, we're going to help you out, we're there for you. And then all of a sudden your case is done. We've done the important piece, and now you're on your own. Like with domestic violence, as long as you're willing to continue or trying to get a TRO, as long as you're trying to continue to get that TRO, we'll help you with providing therapy or counseling or something. But as soon as you achieve it, you get nothing. Or if you decide that you don't want to.
No.
But the idea is
I want to be clear on what we're saying.
Yeah. Well, the idea is it's deriving its legal nature from the case.
Can I make a point on this though? So and correct me if I'm wrong, because I wasn't on this committee, but it seems to me like that's just the nature of what we fund, is we fund legal services. And it's not that we're saying we think it's good to hang people out to dry. It's just that that's not where the money can go under the statute. And so I'm not sure that we, if the concern is you think that like clients will want therapy and therefore will pursue, for example, a TRO, like it's somehow exploitative, if that is the concern, that there's something coercive about this? Because I'm not sure that
I wouldn't phrase it that way, although I think a really terrible attorney or a really terrible incentive structure could result in that sort of behavior. I'm more concerned about like overall, if we're, what are we incentivizing there, and what's going to happen to these people who are in really difficult situations if we're only doing the patchwork, when really what we should be saying, and I'll just go say, maybe we shouldn't provide any funding for that unless we know it's going to be continued through some other funding mechanism.
Yeah, I mean, you don't want to accidentally harm people or something.
I know it's controversial, but
no, I actually think of it differently, which is programs can have different parts of their program. And so there are programs that have social workers on staff, and they also have a legal program. And in that construct, we're saying you can use state bar money to fund the social work services that are related to your case. But when that case is done, you can't use the trust fund money. But that doesn't, we're not saying you should stop providing the other services that your organization otherwise provides. We're just saying you should be using the other sources of funding that fund your social workers to do what social workers are doing. So it's really what can the state bar fund, not what services the program can provide using lots of, other resources that it might have.
I think it's a kind of like the public policy. I remember this coming up in one of our meetings. So like for like, how would the legislature, this often came up in the focus groups too. It was like, well, what would the legislature think if this, they had to weigh in on it? The idea was like some of these services wouldn't be legal services, like, but for the underlying legal aid case, right? So some like MFT sort of like counseling type services, some social worker services, but for the legal aid case that it's getting plugged into, it wouldn't be a legal service. And so that's how it derives its like legal services nature. It's how you get to use this like very, very small, relatively small pot of public funding that's reserved for legal services on this thing that normally wouldn't be legal services. And the legislature might say, well, we didn't create grants for like in marriage family therapy count services. So it's how you get it in. But if the underlying legal aid case disappears, it's like the thing that gave it its legal services nature has fallen away. Or if the attorney's like, this can't be a part of my case anymore for some reason, it doesn't get grandfathered in. And I think at the end of the day, it's like Erica said, it's like, what did the legislature mean to fund?
I totally appreciate that perspective, and I agree with most of it. And I really appreciate what Catherine was saying, that we're not saying that you have to cut them off. My fear is by not saying that it needs to be in some way comprehensive, that my experience with these sorts of programs has been, we build up this trust and then there's some trigger or change in the status, and now there's no funding, and now there's no counseling or therapy. And it really feels like a broken trust. Like, oh, I thought I was going to get help and now it's gone. And that, I think, is more harmful than just saying, well, we can't help you. Like we don't have somebody who can help you on for a little bit, because of the broken trust in the system and just that feeling that you're getting, I don't know how to say it politely, disenfranchised by a system where, if what we were explicitly saying is what I think Catherine just alluded to, was the idea that it needs to be part of a comprehensive provision of services and shouldn't only be tied to legal aid, which obviously could be there and I think is a great way to help fund a portion of that support. That's great, but we're not saying that. We're saying you get money, you get some amount of money to help achieve a legal outcome, and then it's cut off. And if an agency interprets that as, well, now we don't have to help them, that's what they'll do. Or now we don't have funding to help them. I'm sure that's how it would be put. So I know this is controversial because I certainly believe in providing some support, but I also know how painful it is personally when you rip it away and you're like, I'm on my own again, and I'm not really sure where I'm going. But yeah, I welcome feedback. Thank you.
Great.
Can I just jump in
Erica?
just quickly? Well, because I hear your concern, and I think getting to kind of the prior question and how we were sort of focusing on this, our approach and the State Bar Legal Services Trust Fund approach, and I think that is also consistent with sort of the legal aid organization approach, is that sort of the core of the services that we're talking about is the legal service, right? And that's why these other services are called sort of complementary services, because it's all kind of revolving around the legal service. And so these legal aid organizations that are getting into providing social services and whatever it is, are all kind of doing that with a focus on helping people get through the legal issue and get to an outcome on the legal level, leveraging and sort of helping as much as they can on the other stuff that will facilitate that going forward. And I think one of the challenges that we went through here, and as kind of like what we're doing in this whole process, is like, how much are we going to jump in and say a legal aid organization should approach each case a particular way. That right now we're kind of in this like situation where we're seeing that legal aid organizations are doing more holistic services. So we want to help them do that in an effective way and be able to use the funding in a way to facilitate that. But while not directing them to do that or directing them to handle their cases in a particular way or particular manner, or provide, frankly, non-legal services more or less. And so it's kind of a fine line, but that's something that we've kept in mind. And I think, yeah, a lot of legal aid organizations aren't really set up for these other things. They're not they don't have robust social services, social work programs. But, and I've seen this, and this may not have been your experience, but I have seen situations where a legal case ends and they've got, here's a bunch of other organizations that you can now go to help you with XYZ therapy, whatever it is. So hopefully that still catches a lot of the issues that are coming out.
And thank you, Mina. And then I think it was Brady and then Erica.
Yeah, thanks, Will. I had just two observations that I think might help with, thinking about this problem. One, as regulators writing regulation, we're sort of fleshing out the law, and we can't be, obviously we think about the results, but we can't be too results oriented in that once we come to a definition of, what are legal services? Are we convinced that these are legal services? If yes, we fund them. And so we can't sort of back away from that just because there might be some further consequence if an organization makes certain choices, because that's sort of beyond the charge, which is really to figure out what legal services are. And if these are legal services and we're comfortable with that, then we should fund them. We should not fund them because funding them might lead to them not being, somebody getting accustomed to them, not getting them later. And I know that's not very satisfying, but I think the second point is that beyond this process, number one, we sort of have a relationship of trust with our grantees, and we trust them to do the right things by their clients. But beyond this, through the monitoring, through the complaints process, we are engaged in sort of more holistic oversight. So they are bound to the APA standards, and I don't have those memorized, but I imagine there are some responsibilities to do no harm to your clients and connect them with appropriate services. So there are, outside of this rule, ways that we can supervise and encourage behavior. So that might also provide some comfort.
Thank you, Brady. Erica?
So I just wanted to say, Will, I think your perspective is super educational. I think it can get very easy for us as I've done pro bono work, and you want to come in, you want to help, and then you're sort of well, my limited representation is XYZ, and that's kind of all I've got. And I think the problem you're identifying is a problem. I'm just not sure if changing this definition is the solution to that. And I don't know, there may be, and I don't know if this is our role or someone else's, but guidance about, being more clear with clients about what the scope of the representation is or the scope of the services. Because I think ideally all of these services that we're funding, which when you're practicing as an attorney, you want to have, you want your client to be in the best, position that they can be to be in their case. And so you want to have these wraparound services, might be a way to address those issues. But I am concerned about not funding those services because I don't want people's legal outcomes to be hindered because, there isn't funding to help them get into a stable situation to have a good legal outcome that may help with the after effects. And I that's my sort of 2 cents on that. I don't know if that's, like I said, at all satisfying to your concern. And I think it does sort of give me some thoughts on like, how do we address that problem, right? Of you have this intense resources that help you, and then after your legal problem is resolved, those resources aren't there. But I don't know how this definition can, and I don't want to take that away, can help with it. I don't know. Maybe that wasn't really that much helpful of a comment.
I mean, everyone's feedback was really helpful, actually. Yes, is this legal service? Can it qualify as legal service? Then I feel like it's a pretty clear-cut question, but I do think it's important to look beyond. And if you don't want people constantly going in and out of the legal system, then helping them find that stability is a legal services question. You may help with one problem today, but because everything gets cut off and then they're back in, a month, a year from now, because it continues as an issue. And the only idea that came to mind, other than like scrapping it, was suggesting that if there are going to be complementary services, that holistic view that they provide a how do I phrase this? It's not just that it ends, but they have some plan for how it will transition, as Amin said, to other programs that provide those services, or how internally they will handle a referral so that services aren't being cut off. I don't know how I would codify that to say that it should be holistic and look at the long-term legal implications, is how I would tend to phrase it if I were going to argue that it is important to consider that going forward. But I think that would be how I would try to modify the rule. We say cutting it off is bad. So if you're going to use complementary services, how are you going to make sure that they don't put somebody in a worse position after it's no longer advancing a legal outcome?
Yeah.
Does that make sense? Does that provide any sort of?
I agree with what you're saying on a policy basis, but this is a funding provision. And I also am concerned that it puts us in a position of micromanaging and making legal or professional judgments about what's appropriate or not. I mean, I would trust the organization that is providing these services to take into account the needs of their clients. That's the only thing I'd say on that. The one thing I will say, though, I am very eager to get to the last part of the discussion, the definition, second part. We've been going about 2 hours here, and I want to make sure we have enough time to discuss that. So I just want to put in my bid that we at least get to that, so we can see what the overall package looks like.
Great. So that's a great segue. So move on to civil. So yeah, I would say, and this being a definition, like it's supposed to be a definition of legal services, like something where like what I'm hearing, that sounds like kind of like a quality, like Brady was saying earlier, it's almost like quality assurance, or like how like careful are the services and do no harm to your client, which might have a place in the rules, but maybe it's like in a different, rather than in a definition of a term, it's like more like the expectations of like grantees. So I don't know if this gets approved, that doesn't mean that like that door is shut to like looking at like what the standards are for grantees for quality, like care towards clients and quality of services. But that's a great segue. So it would mean I would agree that I think an hour is probably the right amount of time for this next piece. If it's okay, I'll advance, right?
Yes, please do.
Well, the next definition is much shorter, so that will help us a bit. So a little bit of an overview on this one too. The current written rules for the trust fund program, state bar rules don't have a written definition for civil, so there was nothing to compare it to. The proposed definition for civil, like the proposed definition for legal services, more or less sought to capture the existing practice. So not to make some huge sweeping change. So it means to include, this is a circular definition of what this, the way I phrased this on the slide, but it means to include all civil legal issues, and it more or less means to exclude criminal defense work, with the exception of, to the extent that anything listed in Business and Professions Code section 6213L, which was the one the legislature added effective this year, might otherwise be characterized as criminal defense work. That's obviously included. That is in the definition of civil statutorily. So, but otherwise, criminal defense representation is meant to be excluded in the definition you're about to see. And so it explicitly includes civil rights work in response to the one suggestion that we got from a legal services grantee from Disability Rights Education Defense Fund, DREDF. It explicitly includes civil rights work that arises during a criminal case that would not itself be criminal defense legal services. And the example that they gave, and this is work that they do and care about, is helping to assert disability accommodations and language access during criminal proceedings. It slightly exceeds my expertise as a former civil legal aid attorney, but to the extent that civil rights issues, especially access issues, might arise in the scope of a criminal proceeding, they wanted to make sure that that was still considered civil, even though there's it's an underlying criminal case that it's the reason that criminal case exists is the reason the civil rights issue exists, sort of thing. So I'm going to put the proposed definition up, and I'm going to give you all this caveat, which is that Brady from the Office of General Counsel was taking a look at it after we posted the materials and spotted something that would be that staff agrees would be value add. And we shared it with Amin and Catherine, but we didn't have a chance to circle up with them to actually talk about it. So that we're going to be talking about it now as a full committee, which is very exciting. So this is the definition that's in the materials. I did the same thing where I broke it up into bullet points because I thought it was easier to be you could say bullet point 1, 2, or 3, but this presents as a single paragraph in the materials. So essentially, this one's short enough, I'll just read it out loud. Civil refers to legal issues, questions, or processes that arise under any body of civil law and includes legal services related to expungements. This is the statutory items that are statutorily included. Expungements, record sealing, or clearance proceedings not requiring a finding of factual innocence and infractions. As well as, it's a long sentence, legal services related to issues such as disability accommodations and language access, even if they arise during criminal proceedings. So this was in response to the community feedback. And then it ends, a general feature of civil matters is that courts typically handle them outside of their criminal dockets. That's genuinely meant to just be, this is a general feature. It's not like a requirement. And civil excludes legal services related to criminal proceedings, except as this paragraph describes. We kind of felt like it needed something at the end to just say, it excludes criminal proceedings, except for anything that you just read above. And then Brady, you had a really great sort of a critique. I don't know if I'm happy to present it if you want, or you can present it, which is sort of well, the way it's worded, just we need to make sure that it doesn't, to the extent that there is a connection between a civil rights issue and the merits of the underlying criminal law case for this second bullet point. We need to be clear that it's not meant to start criminal law representation.
Is there a way to pull up the actual language we had in the definition? I think it, rather than the way it says in the second bullet point, it was as well as legal services that arise out of civil law.
Well, this is the way, this is the version that was posted. I think the definition you were looking at was one version older. So this is what was posted in today's materials. But the one change, Brady, from the version you were looking at from slightly earlier in the month, was this second bullet point, and I can easily convert this to just be paragraph format. The bullet points are wonky. This second sentence, the second bullet point, we basically had it at the end of the definition. It used to say civil excludes legal services related to criminal proceedings, except as this paragraph describes, and then it was dot, dot, dot. We moved it up in the paragraph and we just slightly reworded it.
Maybe what would be helpful, I only briefly looked because I don't know, maybe I overlooked it. I only saw it today and looked at it today, but it seemed like Brady had a comment to the definition, the second part of the definition, second, right? And so can we just say what that is and then talk about that? That'd be most helpful.
So it's so if I'm remembering correctly, the way it was, the suggestion that first came from DREDF was adding a sentence that said that basically legal matters in criminal proceedings that arise out of civil law, such as disability accommodations and language access, shall be considered civil. And the issue I had with that was that it was over-inclusive. I agree that disability accommodations, language access, sort of procedural things going on in the courtroom should definitely be included as civil. The issue with the way they phrased it in their suggestion was that any issue in a criminal case arising out of civil law would be considered civil. And there are, again, I'm not a criminal attorney, but I can think of ways that the merits of a criminal case might depend on interpretations of civil law. The issue I came up with was if you're charged with fraud for, claiming Social Security benefits that you're not entitled to, that's a crime, but it depends on some interpretations of civil law. That are you entitled to Social Security benefits? That's clearly the merits of a criminal case. So my suggestion was to say civil issues not related to the merits of the criminal case. With this sort of framing.
So we did not
I don't know if this
adopt
problem
directly.
exists.
Yeah, we didn't really adopt their language. We, in two different iterations, tried to get to the essence of if you needed a disability accommodation in your criminal case,
Right.
that should count. They didn't actually address language access. We wanted to give another example and say language access so that you can understand the proceedings also should we could be clear about that. So that's how
Yeah.
we got to this version, but different than from I think it gets at the essence of what DREDF was trying to clarify, but we were trying to do it in a different way.
Yeah, I think that this addresses my concern.
I like, actually, Brady, your idea of tying this to the merits of the criminal proceeding, because I actually would suggest that second bullet be slightly broader in one way, which is related to issues such as including public access, disability accommodations and language access that do not relate to the merits of the criminal proceeding, because those are civil law concepts.
I think that this actually was switched from being over-inclusive to now slightly under-inclusive, as you point out. As well as legal services related to collateral civil issues, or civil issues unrelated to the merits of the criminal case. You don't want to get too wordy, but that's the idea.
If it's okay,
you could add 3 examples.
Can you make the change right now?
Yeah, I'm gonna switch out of presentation mode. So if we want to wordsmith it, I can wordsmith it. That's it. Just you'll lose my screen share for a moment.
Can you do track changes, Chris, just so we don't lose?
I don't know if you can. Can
You cannot do that in PowerPoint.
Okay.
I am frustrated on a daily
Okay.
basis.
I can copy and paste it to a Word document and do track changes, and I'll share the Word document.
I don't want to get fussy. I just thought it'd be easier. Whatever is easier.
It would probably be easier, but you can't do it in PowerPoint.
Let me do it in a Word doc, because I can just use it, and I think it'll be easy enough. And Brady, I when I saw your suggestion with you inserting language like unrelated to the merits or something, I actually thought that was very smart. So I liked where you were going with it. Let's see. Okay, let's see. Can you all see the Word document? I'll try and get it as big as I can.
Now too big because it's not going to fit there. That's perfect.
Okay,
perfect.
Let's do track changes. And then Brady, I actually copy and pasted. It's in track changes now, so this will be a different color. But Brady, this was the language you had suggested for the final sentence. So here everyone says civil excludes legal services related to criminal proceedings except as this paragraph describes. Brady was proposing an edit to a different version of it, but essentially he had this at the very end, except as this paragraph describes, and then this was his addition. And those legal issues, questions, or processes in a criminal proceeding that are not, it wouldn't be in all caps, but that are not related to the merits of the case and that arise under civil law, including, for example, courtroom disability accommodations and language access. So I just put that there for comparison. But there it is. And I'll actually make it look like a paragraph because this is how, allow me to take track changes off for a second. I'm gonna actually, it's no longer in bullet point format. This is how it actually looks in the materials. There you go.
I like the idea of, so I added what's there in red was what Greta suggested is the last sentence, and then I added the capitalized. I think as a matter of making the rule make sense, it makes sense to not, excludes legal services except as described above and below. I think it makes sense to reorder as you do, but I think maybe for clarity, put a period after infractions and then have a new sentence that deals with this concept. And I think maybe I could take a stab at it, but I think Judge Seligman's additional example is illustrative, and maybe we use the merits distinction. Can you give me a minute with my?
Oh,
take your time. Yeah,
I mean, the version that was before this version had the language at the end, Chris. And then that call one afternoon, Amin and I rewrote it because we thought that was confusing.
we moved it up, right? That like allowed above and then allowed below.
Right.
Yeah.
So I would put a period after infractions. I would say civil legal services also include I'm wary of using a word like collateral because it's like, oh, what does that mean? But civil legal services also include.
You could just say related issues.
Just get rid of the two.
Yeah.
Non-merits issues such as public access, disability accommodations, and language access that arise during criminal proceedings.
Say also
I don't
include
think you need to
non-merit issues.
Yeah, also include non-merits issues such as public access, disability accommodations, and language access that arise in criminal proceedings. I don't think we need to say even if, because if it's not in a criminal proceeding, then it obviously.
Did you say public access?
He said public access before disability accommodations and language access.
Thank you. And is there a comma after disability accommodations? Or is that like one, is disability accommodations and language access one idea?
I think it's two things. So get rid of the and, put in issues after access. Get rid of the comma, and that arise during criminal proceedings.
That arise?
Yeah.
So I mean, generally, I think it's fine. Is non-merits clear? Non-merits, we're not trying to say, I don't know.
Well, why don't you're just saying the merits of the criminal prosecution.
Right.
And that's all we mean. Maybe that should be clarified. I also wonder why we need, given all this, the next sentence about a general feature of civil matters is courts typically handle them outside their criminal dockets. Is that really necessary?
Yeah, that does seem extraneous.
I think we'd had a discussion about potentially taking that out, and there was a reason why we left it in. Do you guys remember, Chris or Catherine?
I think we wanted to beef it up, right? But now,
Well, the only thing I can think of is if you take it out, which I think staff is probably fine with, there's no point where you affirmatively say what criminal is. So it's just you're kind of like criminal becomes the exclusion of anything that's not civil, which is totally functional for this definition. I think we probably wanted a sentence that was like, well, what does criminal look like? Oh, generally it's something that courts handle outside their, or like, oh, I guess we're actually saying it's a feature of civil, not criminal. That was the only thing I could think of, was we kind of thought we needed like something to describe criminal. And so we hooked it on criminal dockets.
Actually, criminal is a much more precisely defined term than civil.
Penal code or something like that.
Yeah. And there's a range of things that go into that. I don't think that's an ambiguous term. We've been struggling with civil because it is a more amorphous term, I think, than criminal is.
Yeah. Oh, I should say we looked very hard for a great definition of civil we could just steal, and it's not readily available. It is it's mushy. Yeah, I don't think staff would strongly defend this. If the working group is okay striking that sentence, we can make it more succinct. The definition can be more succinct.
Yeah, I agree with get rid of non-merits and just add after during criminal proceedings that do not
So just,
relate to the merits.
exactly, just take
prosecution
it.
Take non-merits out.
But then I think we still need
During
just
criminal
to,
proceedings.
I think we need something there about, these are some
What
examples.
you originally had are that are not related to the merits of the case.
No,
Yeah.
I just,
Because otherwise, this sentence, civil legal services also include issues such as public access, disability accommodations, and language access issues that arise during criminal proceedings. And we're basically just giving a definition by example, which isn't cabined at all. I mean, maybe that's sufficient. Maybe it's clear enough that.
Yeah, right. It's a definition by example, and the original idea was to make the point that the civil legal issue could exist because of the existence of an underlying criminal case, and that's okay. It doesn't become, it's still civil, and then so that's what DREDF wanted to see, and then Brady, you were like, well, if we're going to go that far, we should make sure to just be really explicit that it shouldn't be getting at the merits of the underlying crime, like the guilt or innocence of the client.
is there any advantage to having the first sentence and with like the definition and the rest are really examples to me? The definition of civil refers to legal issues, questions, or processes that arise under any body of civil law, period. And then they include, and then the examples are all kind of together then, right?
Yeah, although the last sentence is necessary to the definition because the first sentence on its own would arguably include, again, any civil issue that, if I went and looked at the criminal jury instructions, there's going to be a lot of citations to civil law in there.
Yeah, I wasn't talking about, I mean, I guess the question is for the last, I wasn't talking about taking out the last sentence. Maybe it belongs up above. Anyway, I don't really, it doesn't really matter to me, but I think we're all just trying to find a way to make this clear and succinct, right? I mean, that's. But this is okay with me the way it is, so.
It actually doesn't give me any heartburn.
I mean,
Yeah, I think I'm. Then my only thought is, do we want to include some, when we say civil legal services also include, do we want to characterize what those issues are? Or are we using this simply as just these examples? Because we're saying issues such as, like what other issues might be included? So should we say something like
I see.
procedural issues,
Yeah.
civil issues, something like that.
It is a little awkward to me that the definition is the list, but yeah, that's.
I mean, to me, the definition is the first sentence and the last sentence, which is why I was trying to figure out, should the definition be merged into one? So it's arises under civil law and it excludes legal services related to criminal proceedings, except as described below. And then there's examples of what is like outside of it. But I actually don't, we could, there's a lot of lawyers on this phone call, so we could spend a lot of time, like, what's the best phrasing of it, but.
So Will has his hand up, but I want to make a comment, like, it's really hard to write during a meeting. So one option is you can always approve in concept. It doesn't seem like we're in disagreement. And then maybe Brady and Chris can work on this. It's going to go to the commission in 2 weeks. And then we can bring back some to the working group. And then this whole working group, we will see it at the commission meeting. But it's not controversial is why I'm hearing at least this piece.
Yeah, no, I think that's a decent suggestion. Just, I mean, honestly, Amin and I can say there's been any number of attempts to make this as clear as possible. And I think this might be the 5th or 6th version of it at this point. So like, if you can use us as a person just to check a group to check in.
Yeah, that would be nice.
But conceptually, I don't think there's any disagreement, which is what I think I've said that at every version of this. So
But let's let Will weigh in and see if that changes.
Well, yeah, I just had a list of 4 instances, and I'm sorry, I am ignorant on where these would fit, but I just wanted to make sure that I was clear that these would be included. So just interrupt me if there's anything not included. My first one is like immigration matters, appearing before an immigration court and all of that stuff. Any immigration issues?
Civil.
Okay. Tickets like Metro, if you get a ticket from a Metro employee
Infractions,
most likely an infraction.
all good.
Mhm.
Yes. Parking tickets or holds on your registration, all good.
That's all the
Code
findings.
violation.
Yeah.
Code violations for your lawn being out of order or whatever. And all of that is covered and safe. Oh, SNAP benefit programs like eligibility or.
That's already I think
That's all civil.
Yeah. that's all.
Unless they, I guess, accuse you of fraud and then refer it to a, then it becomes criminal, but then you get public defender. Okay. Great. Okay. It's not clear to me from this, like if this is civil,
Good job
but
with the list.
I just wanted to make sure that all of
That worked
those
out well.
were on there, and in which case I concur. I think generally we're all in agreement.
Well, that's great. And I don't mean to like rush us along, because the only other slides I have left is like Flax feedback, which was all positive, and then it's a resolution, which we'll take a moment to phrase it so that we're proving this in concept. But is there more that you all wanted to discuss with the definition of civil?
My only suggestion, because I know, Chris, you don't have that many more slides left, is the only thing I heard that is I didn't hear consensus on was the issue that Judge Sullivan raised. So I don't.
Yeah, and I don't know if I wouldn't say like it's such an important issue, and I don't know if we need consensus, right?
No, we don't need.
everyone
Yeah,
has to agree? Yeah, okay. That could be one where I could see like maybe it's not perfect. Yeah, it's not a unanimous, but right, I don't know if.
Yeah, and I don't know.
Yeah,
I don't know. We don't need consensus, but I didn't know if you wanted more discussion. I guess
there's time. Yeah, there's time. We don't want to rush. This is super important.
Okay, but okay, yes, we should discuss it, and I might just get on the phone for the last few minutes of the discussion, if that's okay. Is that allowed now under these, like, I don't really understand.
Well, the Bagley Keene is, you don't have to notice your location, so that is allowed now. It wasn't previously.
Right.
Let me go back to my slides. It always does this thing where it puts me into presenter view, and it goes, okay. So yeah, thank you, Dwan, for suggesting that we return this one, because this is the one thing where I guess, yeah, it was sort of, there felt like there's more that people could discuss. So, well, let me just do this really quickly, because after this is just the resolution, and then we can go back to the definition of legal service. This is just really quickly wanted to say we are very thankful to LAC for, as it usually does, circulating the proposal to its membership. We were able to give them a little more time to do this one because it was a big topic. So they circulated it for roughly 3 to 4 weeks. They met with many of their members. They found general agreement in the community for both definitions. The one other comment we got was from DREDF about the definition of civil and just like making sure that access work and disability accommodations work can still be considered civil, even if it's in the context of a criminal proceeding. And then LAC just made a point of saying that the community generally agree that there is a need to keep what is very finite public funding for civil legal aid in what is more or less traditional legal aid, while still allowing those programs to tackle their clients as indigent communities challenges in a really creative, strategic, maybe at times holistic, but like a sort of like full scope way. So a combination of strategies like representation and direct policy advocacy. And they strongly endorse the process of meeting with the legal service community on the front end, such as through focus groups, before circulating a definition. They thought that was an effective strategy. So that was it. So we can go back. The next slide would have been the resolution. So I'll go back to this one. And let me know if it's, I thought breaking up into bullet points would be easier because people could then say bullet point number 3 or 4. But if it's actually better to just look at it as a paragraph without the bold, I can make it look like that. So yeah, so the question about sort of like holistic services and should it be defined as legal services as opposed to non-legal services, sort of like as far as the IOLTA statute intends, whatever that means, right? The purposes of the IOLTA statute, what it seeks to achieve in society. I don't know if anyone else had more thoughts
Chris,
on that.
I sort of missed that last point. What in this definition, what were you asking about in that just the last point?
So I think the question Judge Seligman raised was about how we handle what programs sometimes call holistic services, and whether or not we define them as legal services, and how we answer that question as far as like what the IOLTA statute intends, or the purpose the IOLTA statute serves in society. So the staff in the working group drew these boundaries that sort of like, I got another term that we sometimes hear for holistic services are like wraparound services, like trying to meet the interconnected needs the client has. It might not just be purely need for legal advice. It might be in conjunction with other physical, medical, shelter, or any other needs they might have. And if you deliver more than just the pure legal service, you might be maximizing their chances of success in their legal case. And Judge Seligman did a much better job than I'm doing of making his point. But I was just saying staff in the working group kind of drew these boundaries because at the end of the day, they wanted to make sure that if we're calling something legal, it would comport more or less to someone's sense of what legal means, or such as by the complementary service prong, it has these like 3 elements that tie it back to a legal case. And that's kind of like how we get it in the door. So I don't know if anyone else had any concerns or thoughts, or Judge Seligman, you wanted to like come back to it one more time and do a much better job than I just did of making your point.
No, I don't have any more to add. I think as a practical matter, we'll see how these issues arise. I think I've raised the issue, hopefully to sensitize the working group to some of the concerns I have. You get down to concrete examples, though, in applying this would be most effective. And I'm willing to live with this language for now.
And I guess one thing I'll add is I know this was heavily discussed in the working group, but as well as when Selena's on, so she can share too, they also convene their own working groups. And I think one of the themes that kept on coming was a lot of programs didn't want to dilute the funding. So they were in support of the working group's definition because they felt like it was reasonable without being overly broad to allow maybe perhaps work that isn't, that we don't think is clearly qualifying, that if a new organization came in and did majority of their work was that, you know, they didn't want to dilute the funding. But I don't know, Selena, if you wanted to add more to that, but that, I think that was what was communicated to us.
Yeah, I'm happy to add. And sorry, I have a mask on. Let me go to, I'm in my own house, but I'm wearing a mask. Let me go to a room where I can take off the mask. So you can hear me better. So I think that's the biggest takeaway from our meetings with folks is that they wanted to be able to provide holistic services and do whatever they needed to ensure better legal outcomes for their clients, meaning using social workers and other professionals. But that fear of dilution was really, really a common thread throughout the discussions we had, is that they didn't want 100 other nonprofits that are not really providing free civil legal services to join the community because they provide some of those other complementary services only. So that fear of dilution was important. And I think that also goes back to legislative intent as well.
Thank you, Selena. Well, staff is just mindful of not wanting to like rush the committee, but like when you're ready for a resolution. You can
Yeah, so I guess it sounds like for the moment, people are fine with the definition of legal services and conceptually fine with the definition of civil legal services, subject to some additional wordsmithing. So assuming I'm right about where that is, then it seems like you need a motion to approve that, right?
Mm-hmm. You might need to modify that motion that you had, Chris, just to reflect.
Yeah,
that.
we'll need to wordsmith the resolution. So let me exit presenter view. And sorry, when you're not in presenter view, it's zoomed out a bit.
Can we take them separately?
We absolutely can. Yeah, that is an option. Is that better? Oh,
Yeah,
well, it's up to the commissioner. Like whoever wants to make the motion, you can make the motion you like. So, I'll just create 2 resolution slides. Okay, so what I might pitch, if someone ends up making a motion to recommend the proposed definition of legal services, that will be what I'm wordsmithing now.
And then it would take out the yellow, right?
Yeah, there's no exceptions to that one. So I think this would work. Is that large enough for everyone to see?
Okay, it's
Yeah,
Catherine. I will make a motion to approve that, the proposed resolution.
I'm sorry, Catherine, you just said, I corrected a typo. It became definition and not definitions.
Okay, thank you.
Do we have a second?
I'll second.
Okay, Jim seconds.
I'll do roll call. Asaraf,
Yes.
Fight Master, Bennett.
I trust my colleagues.
Is that a yes then, Pamela?
Yeah, I trust my colleagues.
Thank you. Blakemore,
Yes.
Bushelli,
Abstain.
Connolly, Meeker.
Yes.
So Brady, can you help me with the vote tally? Sorry, I always get, because there's 1, 2, 3. Oh, we have 4. We have 4, so never mind. Even with the abstention, it's the majority. So motion passes.
You don't count abstentions as no, so it's
It's 4, right? So I have Amin is 1, Pamela, Catherine, and Jim. So that's 4, and we just need 4. So I did the vote.
Isn't it the number? I mean, I think, did Erica leave? So she doesn't count towards the number anyway.
Yeah, but even if she was,
Okay,
I think either way, we're motion passes.
perfect. Sounds great.
Congratulations. That's that's really great right there. And then for this one, a motion has not been made yet, but I think it might sound like the definition of civil. Do we actually use words like in concept, or how do we want to word this one? Provided, recommend the definition and concept to the commission. And
Or should
delegates to
we-
staff to in the working group to refine the language or something like that.
Or how about just the working group? Because Chris and Brady can propose something and then Amin and Catherine can approve it. So it doesn't have to be both.
So definition of civil in concept.
That would amend State Bar rule.
Can I make a suggestion? If
Mhm.
it's, sorry, Brady, you're muted, so yeah.
Sorry, can we quote the, where is it reflected? Because it's not, it's now different than it was in the memo.
Oh, thank you. Yes. Let's
Can we
actually
just
just
Adopt the
copy
following
paste it.
definition of civil and concept.
Yeah, let me
Paste that in.
what I'm going to do is because we did the changes and track changes.
Yeah.
Well, unless Brady, you want the track changes as part of the resolution, I'm just going to accept them.
Yeah.
Okay. And then you can all, we won't want to rush you. You can just take a moment to like read it and make sure that the track changes didn't accidentally introduce like a typo or something. So this is the track changed version.
Is there some legal reason we don't include "and" between disability accommodations and language access issues? Like the grammar and
I think the
Yeah.
and
Yeah.
got deleted mistakenly.
And
Good
language
catch.
access, is that where it is?
Yes.
Yep.
Okay.
So I would just in the resolution say adopt the oh, you got it.
The following definition and concept. Should we strike amending State Bar rule or?
I would just
or
strike
just-
all that amending, and delegate to the working group. Or
Maybe I'll say the below
Awesome.
definition.
To finalize the definition, right?
delegate to the working group, technical changes consistent with the intent. To be brought to the full commission or something.
that's already in the recommends that the commission adopt,
Oh,
right?
gotcha.
Yeah, so I think that's, you can just end it.
Sorry, I don't know if y'all can hear me, but my audio is getting mixed up, so I might have to leave and come back in. Can you hear me?
Oh yeah, we can hear you now. I think you just need a period instead of colon.
I
Second. Let
actually,
me hop out.
not to
and
be
rejoin.
too
No.
lawyerly, I just noticed it says we're recommending that the condition. The sentence actually doesn't really make sense anymore. Sorry. Adopt the following definition of civil. Geez, I'm sorry.
Yeah.
Adopt in
Take your
concept.
time.
How about
Okay.
adopt in concept, the following definition? Well, we don't want them to adopt it.
Yeah, no, we adopt
Say subject to,
the yeah, subject. Thank you.
subject to technical changes
To be made.
by the working group or made by the working group.
To be made by the working group and submitted to the commission or something.
Only thing you really lost was technical changes consistent with the intent or something, I think.
Yeah. Should we take out in concept and then add?
Subject to technical changes
Yeah.
consistent with intent to be made. So just tuck it in right there, yep.
So getting rid of in concept.
Yeah.
Subject to technical
Yeah,
And then
and
add the
changes.
changes.
consistent.
Yeah. Consistent
with the
the
intent.
intent.
To be made by the working group and submitted to the commission.
Mhm.
Yeah.
But you want to say and submitted to the commission for approval, or that's enough?
Should, yeah. Should we replace put back the language at the beginning, resolve that the Legal Service Adjustment Commission Rules Committee well, I guess, yeah, you can do it at the end, I guess.
I think that's the same because we say submitted to the commission for approval. So
Yeah.
that's a recommendation.
Yeah, sorry. Okay.
So resolved that the Legal Services Trust Fund Commission Rules Committee adopts the following definition of civil. Did we lost our like, I don't know if we need it, but like the reference to like State Bar Rule 3.762A
I don't
or
think we
whatever.
need it because
It's fine.
we have
It's
the definition down
okay.
there. Mhm.
Subject to technical changes consistent with the intent to be made by the working group and submitted to the commission for approval.
I'll motion for this.
Well moves. Should we get a second?
I will second.
Okay. All right, I'll
Catherine
do a
seconds.
roll call. Asaraf,
Yes.
Fight Master, Bennett,
I trust my colleagues.
but Pamela, that's a yes, right? Sorry.
Yes, ma'am.
Okay, thank you. Blakemore,
Yes.
Bocelli,
Yes.
Connolly, Meeker,
Yes.
motion passes.
Great.
With time to spare. There's no way I think you could have
Yes.
done another topic on this. Whoever's
wa-
idea
I
was to
wanted-
move the other one to next week was smart.
I wanted to just acknowledge Chris and his team's work, including the 4 listening sessions that they held and all the work that went into many versions of the memo. I think they just did an extraordinary job and made the working groups work much easier. So thank you very much.
Here. And to both of you, because this is something I've felt passionately about, having tried to seek legal aid, having it so constrained was so difficult, and to see everyone come together and make this happen is
It's great.
very personally very exciting, and I really, really appreciate everybody's work on this. Thank you, everybody. Super cool.
Thank you for that. Well, I mean, just from staff towards the working group, I mean, and Catherine were like endlessly available to us for any number of sudden and impromptu meetings. So they were very giving of their time.
No,
And
I-
Catherine was like on
Yeah.
vacation, like half the
Yeah.
time, that was calling in from her vacation. So like, so that was pretty extraordinary.
No, this working group definitely was a heavy lift. I mean, I know Catherine and me have met for at least 4, maybe 6 or 7 times over the past few months. So we want to thank you. And just a reminder, and I will apologize, there is another rules committee meeting next week, next Thursday. We had to have it back to back. And one of the procedurally what's going to happen is the topic this week and the 2 topics next week are going to go to the commission on August 12th. And the reason being is that we really want to move this to the Board of Trustees. And they only have now, they've changed kind of their structure that only rules can go to the Board of Trustees and that their November or their May meeting. And we didn't want to miss this opportunity to having it go, because it's these are foundational issues, and we've been doing so much work with the Rules Committee that we wanted to move forward to send it out for formal public comment, and then hopefully be able to adopt some of these things by beginning of next application cycle. And that's why we had to try to schedule the back-to-back meetings. So we apologize.
So that's a change to the work plan, because I thought it was going to be later that we would send it for adoption.
No, yeah, we had decided pretty early on, we modified it. Originally, we were going to do
Okay.
everything and package it all at once. And then I think fairly early on, we switched course because we knew it wasn't going to take just a year to do, that this was going to be a multi-year process and we didn't want to delay things. So the thought was then to provide topics in chunks to the board. So the first chunk will be the foundation of issues. So it'll be this topic, civil legal services, definition of indigency that's going next week, and also primary purpose. So those 3, and then we'll follow up with another suite of kind of topics for them.
I'll miss you all next week. I'm on vacation. Have a great time.
Oh, it's a great vacation, Judge Sullivan.
Yeah, well, my family's actually, we're not going that far. We're renting a house up in Sonoma. And all the kids and their significant others and my granddog are all going to be there.
Oh, you deserve it. Well, thank you so much for, and Judge Sullivan's on the topic for next week. So the staff will present with also Rich for that working group.
Okay, great. Thank you all.
Thank you. Thank you, everyone. I'll echo Catherine's comments about staff and also express appreciation to Pamela for her trust in our judgment. And say, you know, a lot of work. I really appreciate all the like heavy, significant, deep, substantive discussion that we've had on these issues. This is critical, and I think it's helping us develop rules that are hopefully going to be valuable for many years to come and relevant. So thank you all. Thank you, Chris, especially for all your work and staff. Dwan, as always, thank you. And everybody have a great weekend. See you next week.
Thank you.
Happy Friday,
Okay,
everybody.
you all too. All right.
Thank you, everybody.
Bye, everybody.
Have a good afternoon.
Bye.